We're gonna go ahead and pull the rest of the quorum out. and-
Okay. And then I'll give my instructions or my announcement.
Good afternoon, Judge Mincy.
Good afternoon.
Am I missing anything?
No, we were waiting on courtroom 2. I don't know if you can go ahead or not. I haven't
I
given
am.
the announcements yet because we
Oh,
had that one case that we took first.
oh. Um. Well, I don't know. I don't know what's going on over there, but
Right.
if you want to get started over here at ACDC, position 19 is McFadden, position 18 is Miss Lyles, and add-on 1 is Farmer.
All right. Miss Bridgewater, Mr. Jordan.
Yes, Your Honor.
I guess I'll do ACDC so we won't be sitting around.
They need to hear their rights, Your Honor.
Right. I haven't even read them today. So let me start with those. All right, ladies and gentlemen, we're going to begin our Fulton County State Court Expedited Accusations calendar. And this is the calendar for cases in which individuals have been recently arrested for certain misdemeanor offenses. And soon after the arrest, the Solicitor General's office has already accused these cases of the offenses brought against these defendants. Nevertheless, this will usually, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a judge, and I am able to address certain matters, including bond, possible plea offers if one has been made by the state at this juncture. I want to begin by advising everyone this whole entire proceeding is being recorded as well as live streamed on YouTube. I want to also remind the defendants that you have certain constitutional rights. The first being that you have a right to representation, so you should know who your attorney is by now. You also have the right to remain silent. Remember that anything that you state about the facts or circumstances of your case can and will be held against you, so govern yourselves accordingly. All right, the first case you said position 19, McFadden. This is 24 CR 003257E. Kirsten McFadden charged with driving hit and run. And that one count. Pre-trial.
First arrest. Jail was a recommendation.
All right. State.
Good afternoon, Judge. This incident took place May 5th, 2024. Officers were dispatched to the intersection of Kimberly Mill Road and Flat Shoals Highway in South Fulton in reference to an accident. Upon arrival, the officers made contact with the victim, whose name is Alexander Young. Mr. Young advised that he was at a friend's house sitting in his parked Tesla when the defendant backed into his parked car. Initially, the defendant tried to exchange insurance information with the victim, but the victim insisted on making a police report because he anticipated that the repairs for his vehicle were going to be very costly. And when the defendant heard that the police were coming, she sped off in her vehicle. The victim was able to take a photo of the defendant's license plate, and that's how she was eventually apprehended. The state is recommending, this is our first arrest, a signature bond through pretrial, and no further contact with Alexander Young, and no weapons, drugs, or alcohol while out on bond. And if we could sound for Alexander Young.
All right. Is Mr. Alexander Young on the Zoom? Mr. Young. All right, go ahead. Is it PD Atai? Is this your case?
Yes, Your Honor. Your Honor, my client is 21 years old. She has lived in Georgia all her life. She is gainfully employed. She runs her own business, just recently graduated from esthetician school. Your Honor, she firmly denies the allegations as stated in the warrant. She states that she left when they agreed, that they had exchanged information. She has text messages and witnesses to that effect. And yeah, she just firmly denies the allegations as stated in the warrant. She didn't hit and run. And I would ask for a signature bond through the jail. I don't think that these circumstances require her to report to pretrial services, and this is her very first arrest. And of course, no further contact with the complaining witness is fine.
Okay. All right, I will order a $2,500 signature bond through the jail. And with that signature bond, I am going to order no drugs, alcohol, weapons, or guns while on bond. And she is to stay away. I'm sorry, have no further contact with the victim, Alexander Young. And I guess she still has a valid license, but I guess be careful while driving. But that's all I'll order at this time.
Thank you, Your Honor.
Mhm. Is this Ms. Lyles? Is this Ms. Lyles? Yes, okay. This is 24 CR 003266F, Jasmine Lyles, charged with one count of battery family violence. Pre-trial.
Third arrest, 2023 battery DV, 2012 battery of freight dismissed. I think jail was a recommendation.
All right. State.
Thank you, Your Honor. This incident took place on May 25th, 2024. Law enforcement responded to a dispute call at 2591 Piedmont Road Northeast in Atlanta. The security guards at the complex advised the officers that Jasmine Lyles, Kiara Browner, and two other women arrived at the parking garage. They appeared to be intoxicated. The guards witnessed Miss Lyles get out of the car and attack Miss Browner, striking her repeatedly in the arm and shoulder area. The guards attempted to break up the altercation, but Miss Lyles' temper proceeded to progress, and that prompted them to call 911. Miss Browner had bruising on her right shoulder and arm area. We found out the two of them do live together at that location, both Miss Kiara Browner and Jasmine Lyles. Your Honor, there also appears to be an open case involving the same two people, both Miss Lyles and Miss Browner, a battery case. They were both cited for battery family violence, but I don't know if there's been an arrest, and it doesn't seem that the case has been accused. But based on that history and the fact that they do have a previous incident together, the state is requesting a signature bond through pretrial services. We're also asking for a one-day anger awareness course. At this time, no further contact with Kiara Browner. Stay away from the incident location at 2591 Piedmont Road Northeast. No alcohol, drugs, or weapons. And if we may sound for Kiara Browner at this time, Your Honor.
All right, Kiara Browner. Kiara Browner. Don't think she's on. PD Atai?
Yes, Your Honor, my client is 29 years old. She has lived in Georgia all her life. She works for Amazon. She graduated from high school. She got her bachelor's degree from Savannah State University and a second degree from Purdue in IT. She does deny the allegations as stated in the warrant. As you heard from pretrial, she's recommended for a signature bond through the jail. So I would ask for the signature bond through the jail. I would object to the one-day anger awareness. I mean, there's possibly ASG Chauncey is saying that there was a case, but there's no open case. I checked Odyssey. She does not have an open case for battery or domestic violence. So I would ask for the signature bond through the jail, and no further contact, and a stay away is fine, but I would like to ask for a one-time law enforcement escort, nothing further.
All right. ASG Graham?
Yeah, just for a clear, Your Honor. So I'm not sure if the case is open, but there was a citation, and both parties did receive one. I don't know if there was an arrest. I couldn't find that. And it just looks like the case has not been accused, but I can pull up that number if you like. It was from February 25th, 2023. Same two individuals in an altercation and essentially beating each other up. So that's the reason for the state's recommendation for no further contact and the stay away. And I think the anger awareness course is appropriate here. And then the signature bond through pretrial services.
But Your Honor, if they were both cited, then I would say that would be something that would lead to a dual arrest more likely.
Yeah,
But there is no open case.
Just to be clear, what I saw in the warrant was that they were both cited, and that was in February of 2023. In this case, Miss Lyles was the aggressor based on the two security guards' testimony. So, the conditions here are for Miss Lyles based on the fact that she does have a previous citation with the same person. And so we feel that the recommendation is warranted, and that's pretty much the state's position.
All right, Your Honor. So I was asking for a signature bond through the jail. I'm fine with the no further contact and a stay away and a one-time law enforcement escort to get her things. I did speak with the complaining witness. She told me that she did not call the police, and she told me that she actually would be fine with no violent contact. But because she was wavering, I thought it would be better just to give them time to cool off for the no violent contact. But she told me very clearly that she cares about her and she wants to have contact with her. But I just, since she was going a little bit back and forth, I decided not to ask for no violent contact.
Pretrial.
Hold on real quick. Let me see something real quick.
Okay.
And while pretrial's in that, Your Honor, so our office has not been in contact with Ms. Browner. So I do appreciate, defense counsel's position, but for us, it's still a no further contact based on that.
All right, here I come, here I come. The last arrest was under a different name, so, but yeah, it must have stayed in Union City, because that's where she got arrested at. But that's all
So
I got.
there's a previous case that was not bound over, but occurred in Union City. And you have that same date, the 2/25/23?
Yes, it's on the GCIC, so she was arrested or cited, because it's on her, it's a part of her cycle. But
Okay,
it was under the name Ariana Browner instead of Jasmine Lyles.
Well, Kiara is the complaining witness.
Well, she must have used a name. I don't know.
But if-
I don't know. I'm just telling you what the GCIC said.
So
interesting.
I did see on GCIC where the Browner's name does appear on Lowell's report, but I pulled them up and they both come up separately. Even though that number does appear, that arrest does appear on Lowell's
Right.
GCIC report.
So it could have been that alias of trying to use that. I do have some concerns. We've got a case in 2023, case in 2024. And so there definitely needs to, parties need to stay apart for a while and get themselves together if they're going to continue in a relationship. So I will order a $2,500 signature bond. I'm going to order it through the jail. Looks like she has enough contacts to be able to come back to court. I'm trust that she will do that. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I'm going to order a stay away from that 2591 Piedmont. That apartment, she needs to find somewhere else to live while she's on bond. And no further contact with the victim, Miss Bronner. So stay away from each other, please. Thank you.
And thank you, Your Honor. Can I also have a one-time law enforcement escort?
Oh, yes. One-time law enforcement escort. Ms. Lyles, you're not to go back without law enforcement, but in order to get your things, you need to arrange with the police so that they can escort you back to get your items. All right?
Correct.
All right.
Your Honor,
Yes.
yes, I need to go back to the first case we heard, Mr. Harden, the prosecutor alluded to this, and as I go, it got a little noisy there.
Yes.
He was arrested on May 1st, went to city jail, Atlanta City Jail. The report says that Grady EMS arrived at the scene, but apparently didn't do anything. He's been incarcerated since May 1st. This is a signature bond case. Unless the state has some intervening activity that would negate that.
Your Honor, I'd like to look into the matter. I can get back with you on that.
Right. Because it doesn't show that on the sheet. Okay. Let's give Deputy Falk a minute to look that up and find out.
Certainly.
Okay. All right. Who do we have before us?
Add on one,
Okay.
Farmer.
All right. This is 24 CR 003289F. Harmony Farmer, charged with 1 count of criminal trespass and damage to property. Pretrial.
6 total. Got an open ag assault in Superior Court. 23 SC 189 844. 2021 battery dismissed.
All right. State.
Thank you, Your Honor. This incident took place on March 18, 2024. Law enforcement responded to a damage of property call at 2900 Landrum Drive Southwest, apartment number 41 in Atlanta. Alita McClendon advised that around 10 p.m., 2 of the tires on her Chevy SUV had been slashed. She further advised that the incident was captured by video surveillance of the apartment complex. On April 10th, law enforcement was able to view that surveillance footage. The footage shows Harmony Farmer pull up near the Chevy SUV, exit her vehicle, stab the 2 rear tires of the SUV, then return to her vehicle and drive away. Your Honor, our office has spoken with Ms. McClendon She says the two were in a relationship. They do not live together. That Miss Farmer was upset because she no longer wanted to have contact with her. She confirmed that she did slash her tires, and also that Miss Farmer keeps calling her from different numbers. She's called her from the jail. She did not answer that call. She said that she's had other people call her to contact her on behalf, asking her to drop the charges. She does not want any contact with Miss Farmer, wants her to stay away from her residence. She also does not want to be contacted by anyone on behalf of Miss Farmer. She indicated she'd be on Zoom this afternoon. Based on the history, Your Honor, the state's recommending a $1,000 surety bond. No further contact with Alita McClendon, and if you can just reiterate to the defendant that does mean through third parties, stay away from the incident location, the 2900 Landrum Drive Southwest, no alcohol, drugs, or weapons while out on bonds. And if we may sound for Miss Alita McClendon at this time, Your Honor.
All right, Miss Alita McClendon. Miss McClendon. All right. Go ahead. It's PD Cook. Is this your case or?
Yes, Your Honor.
Okay.
Your Honor, my client denies the allegations as stated in the warrant. We would be seeking a signature bond at whatever level the court deems appropriate. We would not object to a stay away or no further contact or any of the conditions recommended by the state.
Okay. I'm going to order the $1,000 surety bond. There's an open case in Superior Court that concerns me and her history. So $1,000 surety bond, no drugs, alcohol, weapons, or guns while on bond. Stay away from 2900 Landrum Drive Southwest, and no further contact with the victim, Alita McClendon. All right, that should be it.
Your Honor, this is quorum two. We have our group ready to hear their rights.
All right, let's hold on a second. I see Deputy Falk back.
Yes, Your Honor. Daniel Hardin, everything I'm seeing shows that he was not booked in or arrested or even placed into the GCI until May 25th of 2024. Now, if PD Cook has something to the contrary, he's going to need to provide proof of that. But everything we have says that his arrest date was 5/25/2024. That could have meant he was brought to ACDC or brought to the jail, was deemed to have what clearly appears to be some issues that may have required a 1013, gone to Grady, and then was then later picked up. I don't know. But even with ACDC arrests, it would have shown him being an entry into the GCIC before May 25th of 2024. This shows his GCIC entry and his booking, him being fingerprinted, booked in May 25th, 2024 on his GCIC, on the jail screen, on everything we have. So it is now incumbent upon PD Cook, if he wants to show that that is incorrect, to show some proof of that.
I'm looking at the incident report, which we almost never get from the Atlanta Police narrative on May 21st. They took him into custody. He was transported to Atlanta City Jail.
That is correct, but that doesn't mean he was actually taken into custody at the Atlanta City Jail. What could have happened is if he was deemed a 1013 or not competent to go into the jail at that point, they would have had to take him to Grady and release him to Grady. So that would not have been an arrest for the purposes of the 72 hours. So unless you can show something that shows that he was sitting in ACDC from May 1st of 2024 until today, you haven't overcome 17462.
I will look into it.
Thank you.
All right, thank you. All right, we'll go back to. Oh, that's it for ACDC, correct?
Yes,
All right, who do we have next?
quorum two, but they haven't heard their rights.
Okay, so let me do that. All right, we're going to begin the Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will be the defendant's initial appearance before a state court judge. So we're going to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. The SAP reset date is June the 11th. And I want to also begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I want to also let the defendants know that you have certain constitutional rights. The first being that you have a right to representation or counsel at this juncture of your case. You should know who your attorneys are by now. And also you have the right to remain silent. Remember that anything that you state about the facts and circumstances or the occurrences of your case can and will be held against you. The state is here and listening. So follow the lead of your attorney. All right. Who do we have?
Position number 13, Miss America Henderson.
This is 24 CR 003262H. Autumn Henderson, charged with 1 count of criminal trespass and damage to property. Pretrial.
First adult arrest.
All right. State.
Thank you, Your Honor. This incident took place on May 26, 2024. Law enforcement responded to a fight in progress call at 2783 Hedgewood Drive, Northwest in Atlanta. Upon arrival, the officer met with Autumn Henderson. She advised that she had been in an ongoing altercation with her boyfriend, Clifton Kendrick. She admitted to slashing the tires on his vehicle. Mr. Kendrick provided video footage of Ms. Henderson chasing him around the vehicle with a large tree branch. The officer observed both front and rear driver's side tires were flattened. Our office has spoken with Mr. Kendrick. He advises that the two are in a relationship. They do live together at the incident location. They share no children. He confirmed the events in a warrant, stated that he was trying to leave the residence when Ms. Henderson stabbed 2 of his tires. He stated nothing like this has ever happened before, that he does not wish to press charges. He's not in fear of her, wants to continue contact, and wants her to return to the residence. He indicated that he will be on Zoom this afternoon. And Your Honor, the state is recommending a signature bond through pretrial services, a 1-day anger awareness. At this time, we're going to ask for no further contact with Clifton Kendrick, just based on the nature of the incident and the fact that it happened just yesterday evening. A stay away from the incident location, no alcohol, drugs, or weapons. But of course, we'd like to sound from Mr. Clifton Kendrick at this time, Your Honor.
All right. It's Clifton Hendrick. Clifton, is it Hendrick?
Kendrick, I see him.
Kendrick with a K.
Yeah, ma'am.
All right. Do you wish to address the court today? Yes or no?
Said I just want. Said I just want her to come home.
No. I asked you a question first. Do you wish to
Yeah, ma'am.
address the court today? Yes or no?
Yeah.
And if you, okay, then I'm going to swear you in first, and I'm going to ask you 2 questions. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. 2 questions for you. Are you in fear of Miss Henderson?
No, ma'am.
Do you want to have any further contact with her?
Yes, ma'am.
Okay, that's the only thing I need to ask. Any cross-examination by the ASG or by the PD?
No questions from the state, Your Honor.
No, Your Honor.
All right. You can, well,
Your Honor, my client is 19 years old. She is a Georgia resident. This is her very first arrest. So I would like to ask for a signature bond through the jail. And as you've heard from the complaining witness, he still wants contact with her. They are engaged, they have been engaged for a year, Your Honor. So I would ask for no violent contact and I would object to a stay away. And again, I would ask for a signature bond through the jail. He told me that he does want contact with her and he didn't want to press charges, and it was and Your Honor, my client does deny the allegations as stated in the warrant.
All right, I'm going to order a $2,500 signature bond through the jail. I'm going to order right now a stay away. We need the cooling down period. This just happened. Stay away from 273. Was it Headwood or Hedgewood?
Your Honor, I'm sorry. She did move here from another state a few years, 2 years ago, I believe, to live with the complaining witness. She doesn't have any other family or anywhere else to go, and she's only 19 years old.
I understand. She's gonna have to find somewhere to go. I'm not sending her back to that situation because it sounds kind of volatile. Gonna make sure that they've been able to cool down from it. And it's been only about 24 hours, right? So
Just a little less, Your Honor. In the address, there's 2783 Hedgewood Drive, Northwest.
2783 Hedgewood Drive, Northwest. All right, I'm gonna order the stay away and no further contact for now. Things get better, apply for a modification. But I want to make sure that the victim rather, he's going to be safe and that they have had time to cool down. That's it for the ruling. No drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor.
Next, we will go to position number 22, Ms. Wuzuzu Precious.
This is 24 CR 003284A. Precious Nwazuzu, charge of 1 count of reckless conduct, pretrial.
Fourth arrest, 2019 FTA, 2018 battery DV conviction, 2017 trespass dismissed.
All right, state.
Good afternoon, Your Honor. The defendant is accused of leaving her 4-year-old daughter at home alone while she went to work. Officers arrived at the incident location 635 Jet Street, Northwest Atlanta, and met with Miss Billy Walker, who was the individual who discovered that the 4-year-old was left alone at home. Our office has had a chance to speak with Miss Walker, who identifies as a community advocate. She stated that her and a colleague of hers follow up and give food and snacks to households to make sure that everyone is safe. She advised that the defendant has wanted to keep her daughter as there was previously a defects case against her, so the community has been helping her do so. Ms. Walker stated that the child was okay and was not harmed, and that she believes that the child is currently with her uncle. The state is recommending a signature bond through pretrial services, no drugs, weapons, or alcohol while out on bond, for the defendant to follow any provisions of the current defects case and a 1-day parenting class.
All right, PD Atai.
Yes, Your Honor. My client, I'm sorry, I didn't write down her age. She's pretty young, Your Honor. She has the 4-year-old child. She does deny the allegations as stated in the warrant. She states that she loves her daughter very much and that Billy Walker is actually not a community advocate. She's just the child's daycare teacher who called the police. So, Your Honor, I would ask if there is a defects, if defects is involved, Your Honor, I would not object. Of course, she's going to comply with any defects orders. The child is right now with my client's brother, who's her uncle. My client has struggled with homelessness, and I know she has the 2019 FTA, but I think she was very pregnant or just had given birth at that time. And she has struggled with homelessness and has moved around. She's a single mother, Your Honor. The warrant does state that she told the police she didn't want to lose her job, and that's why she had to leave before the babysitter showed up. So I would ask for a signature bond through the jail in this case. I don't think she has a lot of criminal history. I think a 2017 dismissed. There was something maybe from 6 years ago, battery, family violence, and I didn't look into that, Your Honor, but she's been a good mother. This was a one-time thing, and sometimes if you're a single parent, she didn't want to be homeless again. She didn't want to lose her job. So I would ask for a signature bond through the jail in this case. She has a $600 surety bond set right now, so I don't think we're really far off from, being able to give her a signature bond so she can get back to her job and her child. Nothing further.
Next, I have some grave concerns. Some people then go ahead and take the children to work with them rather than leave a 4-year-old home alone. I hear all the excuses and the reasoning. But I just, find it hard to believe if a 4-year-old was left at home.
She did tell me that someone was supposed to be coming.
So it
They hadn't got there yet.
Yeah, so it seems like the child was left alone per the warrant at 5:33 p.m. and officers arrived at 8 p.m. and no one was there except Miss Walker, who discovered the child was by herself.
3 hours. Okay. So she currently has a $600 surety bond.
And Your Honor, she is recommended for a signature bond through pretrial services at level 2.
Well, I don't want to put too much more on her if she's going to have to go through the DFACS reunification of their plan or what they have her going through. And if there is an open DFACS case, I guess she will be taking parenting classes. So I'm going to.
Your Honor, if I may.
Yes.
It is not clear DFACS is involved. We normally make that recommendation where we believe DFACS should be involved given the circumstances, but we actually don't, I believe, have any proof one way or the other that DFACS has actually gotten involved. It's just a normal recommendation we make where there's a child involved who is endangered.
Oh, so, I was trying not to do anything contradictory to what DFACS may be doing, but if they haven't stepped in yet, I'm going to do a $3,000 signature bond through pretrial. I'm going to have her to take a parenting class. Does pretrial have a parenting class?
I think so. I don't know. But level 2, right?
Yeah, level 2. No drugs, alcohol, weapons, or guns while on bond. And she is not to leave her child alone at home under any circumstances. So she can't leave the home until the sitter has gotten there or she finds a sitter to drop the child off to. She needs to make some better judgments with that. So she's not to leave her child home alone while on bond or ever. And I think that's all I can order at this time. All right, that is it.
Next, we go to position number 14, Mr. Marvin Hunt.
This is 24 CR 003279A Marvin High. Charge at 1 count of battery family violence. Pretrial.
This is 10th arrest, 2016 assault. A couple of 2013 arrests for disorderly conduct convictions. 2010 theft and battery.
All right.
Judge,
State.
this was supposed to be a conflict case.
Oh, is this Miss? I saw Miss McLeod come on earlier.
Good afternoon.
There she is.
I'm here
Oh.
to represent Mr. High.
Okay, great. Thank you.
I'm not sure if she had a chance to speak with me.
Yes, I've spoken with Mr. High.
Oh,
Okay.
great. Thank you. All right, State.
Your Honor, sorry, one moment. This is a cross-defendant case. Do we want to take the cross-defendant at the same time?
Yes.
Okay,
What's the other name?
that would be, I think, Kane, if I'm not mistaken.
Yes,
Payne?
Kane.
Yeah.
Kane,
Okay.
Kane. With a
See-
C.
Oh, C.
Yeah.
Okay.
That arrests 8 total. 2021 out of Louisiana for domestic abuse battery. 2016 and 15 contempt of court, and wanted out of Fairburn.
Well, he has an open warrant out of Fairburn.
That's what I saw.
That is correct, Your Honor. The facts of the case involving Mr. High is that on May 25th, 2024, the officers responded to a dispute at the location of 3041 Landrum Drive Southwest. The officer spoke with Mr. Kane, who was the victim in this particular case, who stated that his live-in boyfriend was, who is the defendant, and him were in a physical dispute. Mr. Kane stated that while upstairs in the home, he saw a message of a sexual nature in the defendant's phone. He stated that he confronted the defendant about the message and that he and the defendant engaged in a verbal dispute. Mr. Kane stated that he told the defendant to leave and he began to gather his things. Mr. Kane then stated that while attempting to gather his belongings, the defendant pushed him and told him that he was not going to leave. Mr. Kane also stated that he pushed him back. And at that point is when the defendant struck him with a closed fist. Mr. Kane also stated that in self-defense, he struck the defendant back with a closed fist and the two began to tussle. Mr. Kane stated that the defendant and him continued to engage in a physical altercation throughout the house. Mr. Kane stated that the defendant picked up a glass vase and attempted to hit him with it, but the vase, however, he was able to block the vase with his hand. And that caused a laceration to his right hand. Mr. Kane sustained multiple lacerations to his arms, legs, and chest. The two reside together at the incident location. And when you're ready, I think the facts just deviate a little bit between the recollection of Mr. High. The recommendation from the state in the matter, Your Honor, is, one moment, a $3,000 surety bond, no alcohol, drugs, or weapons, to stay away from the incident location, for him to have no further contact with the victim, and for him to complete a family violence intervention program. Nothing further to add from the state.
Your Honor, my client is 38 years old. He is employed, he tells me, and he has been living at this address for some time. He tells me that he and Mr. Kane do not actually live together, although they are in a relationship. He said that he was not the primary aggressor and that it was a misunderstanding between them. He would like to have no further violent contact with Mr. Kane because they are in a relationship. I would ask for signature bond for my client, Your Honor. I don't believe that he has any history of a violent nature. So based on that, we would definitely be asking for a signature bond so he can get out of jail and get back to work. He tells me that he was arrested on Saturday and has not been able to make contact with his job. So of course, he is concerned about losing his job. Nothing further, Your Honor. Your Honor, I believe you are muted.
I'm sorry. I thought there was a 2016 assault and a 2010 battery, no? In the history. Mm-hmm.
Your Honor, our records indicate that there is a 2016 assault and he has other batteries in his history. And there's a 2014 disorderly conduct out of DeKalb.
Okay.
Are you sure, Mr. Thomas, that this is my client?
I'm sure, because their records kind of were very similar, but the other one has a more recent case. And so that's how I know.
Okay. On Mr. Hyde. I'm going to, I guess I will order a $3,000 surety bond. And with that surety bond, I'm going to order, I believe, a stay away and no further contact with the
This is
cross
his,
defendant.
he tells
Mhm.
me this is his home, Your Honor. He says they do not live together, and this is his address. Mr. High.
All right, I
You,
guess when we get to Mr. Kane, we'll find out. Or I may have to hold for a second if I don't order a stay away, but certainly no further contact with
how,
the victim slash co-defendant. Yes.
how was level one? I
Oh,
guess because his history is old, but the other one did have more recent
Yes.
and got the whole. So I'll leave that up to you.
And I think, Your Honor, we may need to, we don't need to put a stay away from both parties. So we may need to parse out with the other defense attorney who actually lives at the location.
oh, okay. Well, then on this case, if he's a level one, I will give him a $3,000 signature bond.
Thank you, Your Honor.
And with that signature bond, I will take it through the jail. He's working and seems to have decent contacts. I'm assuming he'll be back to court. So I'll do a $3,000 signature bond through the jail, but no further contact with the victim slash co-defendant. I will leave off the stay away unless I hear anything else. All right, so can we go to Mr. Kane? That's position 4, I believe. Yeah.
I gave you that history, right?
Yeah. No, did you?
I don't believe so.
Yeah, I
No.
gave both.
Oh, you get
I'm
both?
sorry. Yeah, Kane has the 2021 domestic abuse battery out of Louisiana.
Yes, and I think that there's still a bench warrant attached to that, if I'm not mistaken.
Yeah, he the one wanted out of Faber.
Okay.
And in brief, I'll go through those facts a little quicker. But his recollection is that he stated that he relocated himself upstairs, and the defendant in this case. So I guess Mr. High stated that he relocated himself upstairs, and Kane began to curse and yell at him and demanded that he leave the home. However, he refused. At which point he demanded that he leave the home. At which point he refused. Mr. High stated that when the defendant punched and struck him that's when the defendant punched and struck him with a closed fist. He stated that he began throwing items around the house and continued to break items. Mr. High stated that the defendant picked up the glass himself and broke it and cut his hand. Mr. High stated that the defendant continued to travel throughout the house, throwing and breaking items. He also stated that the defendant picked up a shelf and threw it, causing damage to the upstairs window. Mr. High also sustained multiple lacerations to his lips, scratches to his arms and chest. And again, the two reside at the incident location. Your Honor, given the recency of domestic violent history, the state's request is a $3,000 surety bond, no alcohol, drugs, or weapons. We'd like for this defendant to have to stay away, for him to have no contact, and for him to complete a family violence intervention program. Nothing further to add from the state.
All right. And who represents Mr. Kane? Oh, Mr. Cook, B.B. Cook. You're on mute.
My client lives at 850 Stonehaven Road, Atlanta. I don't believe that's the incident location. Is that correct? There'd be no problem with staying away from, that's not, he doesn't live at the incident location. There's no problem with staying away or no further contact. He denies allegations as stated in the warrant. We would be objecting to the FBIP, and we would be seeking any anger force. We'd be seeking a signature bond at whatever level the court deems appropriate.
Well, the signature bond, he's going to Fairburn.
Yes, I guess he would go to Fairburn on that.
Do you by chance know what the charge is in Fairburn?
I do not, Your Honor.
Hold on.
I know he has the 2018 arrest for driving while license suspended or revoked. I'm not sure if it's the same charge that has the bench warrant.
He believes well, no, I'm not going to.
Yeah, it's a FTA warrant.
Okay.
Okay,
That's likely that charge.
Yeah.
okay. All right, how old is Mr. Kane? 30?
Which kind is, almost 30. He'd be 30 in, July 27th. He is also working, in the fast food industry and has been for 16 years. And he is currently employed as a district manager for a fast food, company.
All right. I will give him a $3,500 signature bond. Signature bond through the jail so that he can be transported to Fairburn. I'm gonna order stay away from the incident location, no further contact with the co-defendant, and no drugs, alcohol, weapons, or guns while on bond. That should do it.
Yes. Next, we could go to position number 8, Mr. Tavares Dollars.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may. Thank you so much.
You're welcome. Have a good day.
You too.
Thanks.
Is that Tavarius Dollar? 24 CR 003278J, charge of 1 count of criminal trespass.
6 total. 2024 FTA. 2024 criminal damage to property. That's open in Superior Court. 2023 battery. 2023 trespass.
Your Honor, brief facts of the case is that on May 26, 2024, the officer responded to 1120 Beechcrest Road Southwest in reference to a criminal trespass. The officer spoke with the grandmother of the defendant, Ms. Shirley Bale, in regards to the incident at her residence. The victim advised that her grandson, the defendant, was involved with damaging her front door window, her front door screen door window, and 5 small satellite windows on the right-hand side of the front door during a dispute. The officer encountered the defendant a couple of hours before the incident actually took place and verbally gave the defendant a trespass warning. The defendant came back to the location after being advised to leave said location for the night. The officer was able to confirm the damages via photographs of the crime scene at the location. And there was also a large gray and colored brick object that was near the scene at the location next to the broken glass. The damages on the door were estimated by the victim to be approximately $450. The defendant himself was found walking out of the entrance of the residence upon the officer's arrival. Our office was fortunate enough to get in contact with the victim, who is the grandmother of the defendant. She stated that the defendant lives with her from time to time. She stated that she had to call the police earlier that day because the defendant was on a rampage, throwing things around the house. She also stated that she wanted the defendant to leave the residence to cool down. The officer told the defendant to leave the location. The victim stated that the defendant came back, as previously stated, and damaged the storm door and front door. The victim stated the defendant has possible MH issues. She also stated that there is a previous case, 24 PI, which is a felony, but 24 PI 001887, where the defendant was ordered to have no contact with the defendant, with the victim, and to stay away from the incident location. The victim stated that the defendant needs help. And she also states that she is okay with him returning back to the location. I'm not too sure if that's the best idea at this time, Your Honor. We've already heard about the other cases, but I'd just like to point out that the 2023 criminal trespass out of Marietta, as well as the 2023 battery out of Florida. So he's a multi-state offender. Given the facts and the weight of everything and the idea that he blatantly violated the no further contact bond order in the open case, which that charge was criminal damage to property in the second degree out of South Fulton, the state will be requesting a $2,500 surety bond, no contact with the victim, Ms. Bell in this case, and a stay away from that incident location. And if we can sound from Ms. Bell in accordance with Marcy's law, that'd be greatly appreciated. Nothing further to add from the state at this time.
All right, Ms. Bell. Ms. Bell. Nope. All right. Go ahead, PD Cook.
Is currently a business student.
Yeah, to start off with this.
Okay, I'm sorry. My client is 24 years old. He's been in the Atlanta area about 15 years. He's currently a business student at Atlanta Tech. I spoke briefly to his grandmother and didn't get exactly the same information, but there was no clear-cut demand that he stay away. However, he does not have to go back. He could comply with a stay away and certainly no further contact, and we would be seeking a signature bond at whatever level the court deems appropriate.
And Your Honor, if I could correct a misstatement on the record, the victim did deny the presence of a previous case, which brings the state even more concerned. And so that is another indication for the request by the state.
I see Miss Bell on the line now.
All right, Ms. Bell. Oh, I see Shirley Bell. Can you unmute yourself and answer a question for me? Ms. Bell, can you unmute yourself? Can't hear you.
Hello?
Okay. Ms. Bell, I'm gonna
Yes,
ask you.
can you hear me?
I can hear you. I'm gonna ask you a yes or no question first before I swear you in. Do you wish to address today?
Yes,
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty
yes,
of
ma'am.
perjury?
Yes,
All right, 2 questions. Are you in fear of Mr. Dollar?
no,
Do you want to have any further contact with Mr. Dollar?
yes.
Okay, you put your hand down. All right, I don't have any more questions. Anything else from the state?
Yes, Your Honor, I'd just like to remind Your Honorable Judge that she is the active victim in the open case, open felony case, where he was instructed to have no contact with her as well, to which he violated.
All right. All right, you can mute yourself, Ms. Bell. PD Cook?
Judge, can you hear me?
I can.
Can you order Tavares to go to the VA? He's a disabled veteran and he have mental issues, and I help him with all of that. And what was going on the 26th was some episodes.
Okay, but I don't want to get deep into the facts of it. This is not the trial. This is just a bond hearing. I don't know. I can order him to continue any treatment or things that he needs, you know, to help him. I can order that, but you know, it's going to be difficult, I guess, to enforce it if there's not a plan of treatment in place.
It can be one if I can get him down to the VA.
Okay, I don't know if you'll be able to use this bond order for that, but I can order that if he has a plan of treatment or needs treatment from the VA, that he would continue with that plan of treatment and follow any MH recommendations.
Okay, with the treatment plan, who would I bring it to? Who would?
I don't know. We're not going to monitor his treatment plan. We would not do that. It's just asking him as a part of his bond conditions to continue with that and to go participate to help himself, hopefully. That's where he is at this point, wanting to help himself.
Yes, ma'am.
I would do that so that obviously you as the victim could be safer, hopefully, than you have been in the past. But
yes, ma'am.
continues getting cases, so I don't know. He must need some more treatment, hopefully.
Yes,
Um,
ma'am.
But let me hear from his attorney first.
All right, thank you, Judge.
Huh?
Yeah.
Mr. Cook?
Yes, what Ms. Bell said reflects to some extent my conversation with her earlier by phone, that she is not afraid of him and that she wishes she does wish further contact. Again, we would be asking for a signature bond at whatever level the court deems appropriate.
And this is Mr. Dollar, correct?
Yes,
And you said he was 24 years old?
yes, he is.
And I didn't hear, or maybe I missed it, on working or,
He's in school at Atlanta Tech studying business.
okay. And he has a bond on his open felony, I'm assuming. Does he state?
I'm looking into it right now. I do
Okay.
believe he is on a bond.
He went to felony court?
He is the open criminal
Oh,
damage
the
to
open
property
charge.
in second degree.
Yeah, he bonded out on that.
Oh, okay.
Well, he was rearrested, so it's $2,500 good bond.
Mm-hmm.
So that he got that bond now, plus whatever
Okay.
you said.
Plus this, okay. So I'm going to give him the same, a $2,500 good bond, surety bond. So it'll be 2,500 surety bond. I'm going to order, I think there needs to be some cooling off. This is 525, 526. And have him to go get some help. So I'm going to order, I guess no further violent contact because the victim is here, but it looks like she's the victim in the other case as well.
That is correct, Your Honor. And the incident location is the same as the stay away as well in the other case.
Okay, they need some separation. They need to be apart. So I'm going to order no further contact with the victim, Ms. Bell. But I will order that he go to the VA, get his treatment, and follow any plan of treatment for MH. And do I need to order a stay away or not?
Yes, Your Honor, we'd like you to reinforce that concept.
Okay, stay away from her residence right now. You all need to be apart because this is not going well, obviously. No further contact and stay away from her location. No drugs, alcohol, weapons, or guns while on bond. So 2,500 surety bond. And that's it for this case. Thank you, Ms. Bell.
Thank you, and I appreciate that. Thank you.
Okay. All right.
All right, thank you.
Mhm.
Judge, can you will he? Okay, thank you.
All right, you can sign off.
All right.
Next, we can go to position number 1, Mr. Abdul.
All right, 24 CR 003265C. Javante Abdul, charged with 1 count of battery family violence and the 2nd count of simple battery. Mr. Jordan, can you help Ms. Bell, please?
I'm trying.
Okay.
Got 10 total on probation out of Hall County, possession of a firearm by convicted felon, possession of a Schedule 1. Last arrest was on the 7th of this month, probation, 2022 probation, 2021 parole violation, and an armed robbery conviction, 2016 out of Illinois.
Now, a brief facts of the case is that on 3/28/2024, the officer responded to 3136 Martin Luther King Jr. Drive, Southwest, Unit D11 in Fulton County, Georgia. The victim advised that she had just been assaulted by her husband, the defendant, who was inside of her apartment. She advised that the defendant pushed her to the floor near the bathroom and punched her twice in the right shoulder with a closed fist, causing her to break 3 fingernail attachments. The defendant left the location before police arrived at the location. On a separate day, looks like 4/9/2024, the victim confirmed the accounts of what she told to the responding officer. She also advised that she and the defendant had been married for a year and that they have a 2-year-old daughter together. Fortunately enough, our office was able to get in contact with the victim. The victim in this case is Ciara Dorsey, Ciaradorsey, who advised that she and the defendant are married, but they have been separated since February 2023. They do not live together. However, they share the one child together. She stated that the incident location is her residence and the defendant does not live there. She confirmed the events in the warrant. She stated that during the incident, the defendant snatched their child out of her hand and left with the child. The victim stated that she has since filed a TPO that was granted on May 9th. The victim stated that she has added her child to the TPO, or their child to the TPO. The victim stated that this is not the first time that the defendant has been violent towards her. The victim also stated that they had a case in Chicago in 2012. The victim stated that she wants no contact with the defendant, and she wants him to stay away from the residence. I do not believe that she is on the call, but if we could sound for her in accordance with Marshall's law at the conclusion of the state's request, that'd be greatly appreciated. Again, I'd just like to repoint your honorable judge to the 2018 armed robbery conviction, the 2022 conviction for being a convicted felon in possession of a firearm. He received the 4 years and the 6 months of probation and the 6 months of confinement to which he violated. He also has a probation revocation as recent as 2022. And so it is all of these things that bring the state great concern and would like for the court to give some brevity to the situation. So the request is for the defendant to have a $5,000 surety bond, no alcohol, drugs, or weapons, a stay away from the incident location, a no contact with the victim, Miss Dorsey, and to complete a family violence intervention program. And if that at this time we could sound for Ms. Dorsey in accordance with Marcy's law, that'd be greatly appreciated. But there's nothing further to add from the state at this time.
All right, Ms. Dorsey. Ciara Dorsey. I think I see someone getting on, no. All right. PD Cook, I don't see anyone getting on.
Your Honor, if there is an active TPO, it's going to have pretty much, and it's been confirmed, we would have no objection then to the conditions because they're already pretty much set in stone. We would be seeking a signature bond at whatever level of court deems appropriate.
Well, we're not going to do a signature bond. I'm going to do a surety bond on the battery family violence, 2,000, and on the simple battery, 1,000. So I'll do a $3,000 surety bond. And no further contact with the victim, Ciara Dorsey, or her child, whatever the child's initials are. So no further contact with them and to follow all the other provisions of the TPO. No drugs, alcohol, weapons, or guns while on bond. That should be it.
Next, we can go to position number 2, Mr. Dykell Benton.
24 CR 003267G, Dykell Benton, charged with 1 count of driving without a valid license, reckless driving, and driving hit and run.
12 total on probation for heroin. Has a current FTA, several probation violations, and 2018 FTA. That's it.
All right.
The facts of the case is that on May 10, 2024, the officer was en route to a call when he was flagged down by the victim in this case, the victim being Quentis, Quentis, Cleckley, Cleckley. The victim advised that he was involved in an accident involving a black Volkswagen and an orange Infiniti. The officer observed the driver of the orange Infiniti, and at which point he observed the defendant yell out from his window, "Hey, bruh, hey, bruh, you got insurance?" As he turned his vehicle around. Shortly after, the defendant then fled the scene at a high rate of speed, driving recklessly through a residential area in the West End neighborhood. A hit and run report was completed on the vehicle, but not the defendant at the time because the defendant was not the registered owner. It was later discovered the defendant is not licensed. Your Honor, I do believe that this is a Riverside issue, so we'd be asking for a signature bond through the jail. We'd like to point out to the court, though, the Riverside does not preclude Your Honorable Court from imposing conditions. And so the conditions that we'll be asking for is no alcohol, drugs, or weapons, and no driving without a valid license. And if we can sound for the victim in this case, Mr. Cleckley, that'd be greatly appreciated, but there's nothing further to add from the state at this time.
Okay. Mr. Quintus Cleckley, Mr. Cleckley.
Oh.
All right, go ahead, PD Cook.
Yes, we concur with the state on the Riverside issue. We do not object to the recommendation as made by the state.
All right. So this will be an SOB jail, driving without a valid license. That will be $500, reckless driving, 1,000, and driving hit and run, 1,000. So it'll be a total of 2,500 signature bond through the jail. And of course, the conditions: no drugs, alcohol, weapons, or guns while on bond. No driving without a valid driver's license. And that should be it.
Next, we can go to position number 3, Mr. Miles Bryant.
This is 24 CR 003268E. Miles Bryant, charged with 1 count of cruelty to children in the third, 2nd count battery, family violence. Oh, I'm sorry, and 2 other. So a total of 3 counts of cruelty to children in the third and 1 count of battery, family violence. Pre-trial.
16. You got open pretrial case, simple battery, family violence. 24 CR 000-931E. 2022 FTA. 2019 battery DV DWAP. 2019 simple battery DV trespass DV DWAP. 2017 terroristic threats first offender.
Brief facts of the case is that on May 24, 2024, the officer was dispatched to a location of 540 Humphrey Street Southwest here in Fulton County, Georgia. The officer spoke with the juvenile caller, who we refer to as, who's 10 years old, who we will refer to as KC, who stated that her father, the defendant, hit her mother, the adult victim. The juvenile caller did not specify where her mother was physically assaulted or physically hit by her father. The adult victim stated that the defendant hit her in the face. The adult victim was visibly swollen on the left cheek at the time that the officer arrived. When asked how her face became swollen, she initially stated that the defendant hit her in the face. When asked again, she changed her story and said that he only pushed her instead. The adult victim and the defendant lived together and shared the 3 juvenile children, KB, KC, and another KC, who were all present at the time of the incident. Our office was fortunate enough to speak to the adult victim in this case. Looks like Tedleene, Tedleene Smith, traditional spelling, who confirmed that her and the defendant are in a relationship. They live together at the incident location and they share 2 children together. She did deny that the defendant hit her, and she denied that she sustained any sort of injuries. I do believe that she is on the call today. She stated that the defendant was intoxicated, and she wanted the defendant to leave, and that was I'm assuming that's why the police were called. But again, a reminder, the juvenile called the police based on what she allegedly saw. Your Honor, we just want to again remind you that she is the same victim in the 2019 case, which for simple assault, family violence, and criminal trespass. Another 2019 battery, family violence case where she is the same victim. And again, she is also the same victim in the case from February of this year, where he was lucky enough to receive a $3,000 signature bond through the pretrial services and instructed to stay away from the location and to have no contact with the victim. And so given the brevity of the situation, Your Honor, the request here is for a $5,000 surety bond, or I'm sorry, a $5,000 cash bond to be specific, no alcohol, drugs, or weapons, a stay away from the incident location in accordance with the other stay away on the open case, and a no contact in accordance with the other no contact on the open case, and the completion of a family violence intervention program. And if we could sound from Ms. Smith in accordance with Marcy's law, that'd be greatly appreciated. But there's nothing further to add from the state at this time.
All right, what's your breakdown in the suggested 5,000 cash?
Your Honor, I would say 2,000 on the battery and 1,000 each on the remaining charges for a total of 5,000, I believe.
Okay. All right, thank you. PD Cook, or no, let me sound for the victim. Ms. Smith, is it Talini Smith? All right, go ahead, PD Cook.
Yes, Your Honor, I also spoke to Ms. Smith earlier today. She stated to me that she was not afraid of him. She wants him home. He is working, and that's, I don't believe she is. They do have, I believe, 3 kids together. I'm obviously not, I don't have the information that the solicitors have on the other cases and what the conditions of those were set for bond. We would be seeking a signature bond at the level the court deems appropriate. And if there isn't any other stay away or any other no contact provision that is in place, we would ask that he be able to go home. And if that is not possible, we would certainly ask for a third-party transfer to see his kids and a one-time Leo visit, law enforcement officer visit, I'm sorry, to the incident location or the residence to retrieve his property.
All right. I'm going to, and there's too much history here. And I have to concur with the state. I'm gonna order a $5,000 cash bond, 2,000 on the battery, 1,000 on each of the cruelties. I'm gonna order stay away from the incident location, no further contact with the victim, Miss Smith, and the 3 children. I don't know they've been legitimated, if they're married or not married. They have different last names. So I don't know what their situation is, but I'm just gonna order him to make sure, even though this was a couple of days ago, that there's been enough or ample cooling down of the situation. No, I'm not gonna order any visitation or anything like that, but I don't know if he needs a one-time escort back to the property to retrieve some belongings. I will order that. Whereby he would have to get a officer to escort him to the property to get any belongings. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it for now.
And Your Honor, if the open case, which is the 24 CR 000931E, can be further noticed with this case to the SAP calendar, that'd be greatly appreciated.
Okay. Should get that, Ms. Bridgewater.
No, repeat that case number again.
It is 24 CR 000931E.
Got it. Thank you.
Thank you.
Okay. Next.
Next, we go to position number 5, Mr. Demetrius Cameron.
This is 24 CR 003273F. Demetrius Cameron, charged with 1 count of criminal trespass. Pretrial.
He got 91. He got open trespass in state court 24 CR 002. Hold on. 002106F. Was arrested in April for trespass. FTA from this year, last year. You get the point, I assume.
Yes, Your Honor, the history speaks for itself. Brief facts of the case is that May 25th, the officer was dispatched to 151 Cleveland Avenue Southwest in reference to a black male trespassing at a gas station, that gas station being Exxon gas station. The officer notified the defendant walking by, noticed the defendant walking by the gas pump at the location. The officer then went to speak to him and reminded him that he was not supposed to be present at the property due to him already being criminally trespassed. In the previous incident that led to the criminal trespass, he's alleged to have stolen some items from the location. The request from the state is, the history speaks for itself. So the request from the state is a $1,000 surety bond, a absolutely stay away from that location, the 151 Cleveland Avenue Southwest, Atlanta, Georgia, and for him to actually have no contact with the listed victim that was listed in the warrant. Looks like Malika Kiss, Milkias Negassi, Negassi, who is listed, I believe, as the owner of that location. Nothing further. If we could sound from Mr. Negassi, that'd be greatly appreciated, but there's nothing further to add from the state at this time.
All right. Do we have the victim on the call? Is it Malika Degassi? Don't think so. All right, go ahead, PD Cook.
Yes, Your Honor, my client is 42 years old and has lived in the Atlanta area his entire life. He is not employed. Lives at home with his family, but I'm not sure he's always at that residence. He has no funds to pay any kind of money bonds or surety. That would essentially be a no bond. We would be asking for a signature bond, preferably through the jail so he can move on. And we have no objection to no further contact or stay away.
All right, I'll order $1,000 surety bond. The stay away, no further contact with the victim, stay away from the Chevron. No drugs, alcohol, weapons, or guns while on bond. That's it.
Come on.
Your Honor, if I may.
Mm-hmm.
Judge, I have an appointment at 4 o'clock. I also have the victim on the Zoom chat for Mr. Gomez as well. I just want to see if there's any way that we could get him up to handle this case. And if not, that's fine. I just thought I'd ask.
Yes, deputies, can we handle the private attorney's case?
Who was the client again?
That's on position. 23, Perez Gomez, Benjamin.
Judge, this first arrest jail is a recommendation.
Okay.
Your Honor, can you hear me?
Yes.
Okay, I'm doing a hybrid situation. My microphone on my computer is not working for some reason.
Okay, let me call this case 24
Sure.
CR 003276E. Benjamin Perez Gomez, charged with 1 count of simple battery, family violence. Go ahead, state.
Your Honor, this incident took place May 23rd, 2024. Officers responded to 3267 Elm Street in College Park in reference to a domestic dispute. Upon arrival, they made contact with the caller and the victim, Miss Anise Maison. Miss Maison advised that she and the defendant are dating and have been living together since May 1st of this year. She further advised that she and her boyfriend got into an argument. She found that he had a dating profile online. She confronted him. He became irate. She tried to leave. The defendant pushed her down in a chair and eventually ripped her shirt. It is my understanding that this is a Riverside issue. Our office has been in touch with Miss Maison. She said that her and the defendant have been together 6 months. They don't have kids. They do live together. She stated that nothing like this has ever happened before. She's not afraid of the defendant. She did confirm the events in the warrant. She said this was like a first-time incident and the defendant's not a violent person. She does want contact and she wants the defendant to be able to return to the residence. And this is his first arrest, Your Honor. So the state is recommending a signature bond through the jail and no further violent contact with the victim, no weapons, drugs, or alcohol while out on bond, and a 1-day anger awareness. And if we could sound for Miss Anise Maison.
All right, Miss Anise Maison.
Good afternoon, Your Honor.
Good afternoon. Do you wish to address the court today, yes or no?
Yes, if I may.
Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. I'll ask you 2 questions. Are you in fear of Mr. Perez Gomez?
No.
Do you want to have any further contact with Mr. Perez Gomez?
Yes, Your Honor.
All right, I don't have any more questions. Anything else from the state or any cross-examination by Mr. Bixson?
No cross from the bench.
Nothing from the state, Judge.
All right, go ahead, Mr. Bixson.
Your Honor, this is Mr. Benjamin Perez Gomez. He's 32 years old. He lives in College Park, just moved here from Florida. He has a high school diploma. He's a personal banker. Been doing personal banking for about 10 years now, full time. As previously stated, his girlfriend's the victim. She doesn't want the case to go forward. She's not in fear whatsoever. She wants him to be able to return home. She's been emphatic about that, Judge. And so we are asking for a signature bond through the jail, and we are totally fine with no violent contact, Judge. We have no issue with that or with the class that the state wants them to take. We would just ask for no violent contact instead of no contact.
All right. I will order a $2,500 signature bond through the jail. I will order no further violent contact with the victim. And no drugs, alcohol, weapons, or guns while on bond. And that should be it.
Thank you, Judge. And Judge, I just want to make the court aware, Mr. Perez Gomez has actually been in custody since last Thursday on this. And we were supposed to be in court on Saturday, but obviously, unbeknownst to us, no misdemeanor court. But I want to let the court know that obviously he had been in custody for more than 72 hours.
Right, I see. What was it, 524, 4 days, 3 days? Is that what you all have state?
That's what I have, Your Honor, that he was arrested May 24th at 8:20 p.m.
Okay. All right. Well, I did give him a signature bond through the jail. So, and I thank you for bringing the Riverside to our attention.
Thank you.
All right.
Judge, that completes my business. May I be excused?
Yes, you may. Thank you.
Thank you, Judge.
Next, we will go to position number 7, Mr. Isaiah Cotton.
This is 24 CR 003274D. Isaiah Cotton, charged with 1 count of battery family violence, the 2nd count of criminal trespass and damage to property. Pretrial.
First arrest, resident of Virginia. Jail is a recommendation.
Okay.
Your Honor, not so brief facts, but relevant facts of the case is that on May 24, 2024, the officer was dispatched to 3154 McKenzie Road, East Point, Georgia, in Fulton County, Georgia, in reference to a physical altercation. The victim and the defendant were engaged in a verbal altercation upon the officers entering the residence. When speaking with the victim, she stated that the two were traveling in a vehicle on the roadside at Jackson Road and McKenzie Road. Herself and Mr. Cotton began to engage in a verbal altercation. The victim believed the defendant was involved in a romantic relationship with another person. The victim stated that she asked the defendant to exit the vehicle, to which he did. The victim explained that the defendant began to walk towards the residence. However, she beat him there and arrived there first and locked the front door entrance of the residence. The victim then stated that the defendant kicked the door in, entered the residence, grabbed her and slammed her to the ground and broke her vanity mirror, which was located in the bedroom. bedroom. The officer did observe the damage to the front entrance door as the locking mechanism was destroyed and severely damaged, I guess. The wall frame was unhinged due to the force caused by the defendant as well. The officer also observed a shattered mid-sized mirror in the bedroom. The victim was able to provide cameras that captured the encounter, which was located inside the residence of the living room. The defendant was observed forcibly kicking the front door, entering the residence and proceeding to grab the victim. The two individuals struggled shortly before the defendant slammed the victim to the ground. The victim herself had a bruise located on her knee. Our office was fortunate enough to get in contact with the victim. In this case, Miss Jameson, it looks like Rakia, Rickah, Jameson, Jamison, who advised that she and the defendant are in a relationship. They live together at the incident location. They share no children. She confirmed the events in the warrant. She stated that nothing like this has happened before. She stated that she is not in fear of the defendant and she wants to continue contact. She states that she wants the defendant to return to the residence. The request from the state is a signature bond through the pretrial services. And given the recency of everything, no alcohol, drugs, or weapons, a stay away from the incident location, a no contact with the victim, and for the defendant to complete a family violence intervention program. And if we could sound from Ms. Jameson in accordance with Marcy's law, that'd be greatly appreciated. Nothing further to add at this time from the state.
All right, Ms. Jameson. Ms. Jameson, I don't believe she's on.
I'm here, Your Honor.
Oh, worry.
Can you see me? My power is out.
Oh, yeah, I know we had a few power outages. Are you able to finish listening in?
Yes.
Okay. And then go ahead. Do you want to make a statement to the court or answer the two questions?
Yes.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Are you in fear of Mr. Cotton?
No.
Do you want to have any further contact with Mr. Cotton?
Yes.
Okay. Go ahead, PD Cook, or, well, which PD is it?
It's Mike Ketchum.
Okay.
My client is 27 years old. He is an independent contractor, trucker. They have been in a relationship, and we would ask the court in light of the Miss Jameson's testimony that he received a signature bond to the jail. We object to any stay away or any restriction on contact, and we don't believe he should be required to take anger management or FBIP.
Okay. I'm going to order a $3,000 signature bond through the jail. I'm going to order that to be $2,000 on the battery and $1,000 on the criminal trespass, for a total of $3,000. No drugs, alcohol, weapons, or guns while on bond, and no further violent contact with the victim. And I don't think we need to stay away, right?
Well, the state has requested it, given the recency of the situation. The incident date is, I believe, Friday.
Okay. Okay, we'll order the stay away.
Your Honor, that's where well, not where they live, but they're going to be, if they're going to be allowed contact, I'm not sure why there should be a stay away from her residence. If I'm correct, Ms. Simpson, then Mackenzie Avenue is your residence?
Yes.
Okay.
Not from here. He's from Virginia.
Hold on. I haven't given you authority to talk, Ms. Jameson.
I'm sorry.
Do you want to address the court?
Yes,
Okay.
yes,
Okay. Have I sworn you in?
yes.
Hmm?
Have you sworn me in?
Mm-hmm. No. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Mr. Cotton?
No.
Do you want to have contact with him?
Yes.
Okay. Any cross-examination questions from the state?
I'd like to know who called the police in the matter.
Ms. Jameson, who called the police?
I called the police.
Mm-hmm.
And what was the reason for you calling the police?
I called the police to try to get him removed from the residence, not because I was in fear of him or that I wanted him to go to jail. I just wanted him out of the house.
Had you requested that he leave?
Yes.
He refused? No further questions from the state, Your Honor.
All right. I will continue on with the $3,000 signature bond through the jail. And no further violent contact with the victim. That's all I ordered. Oh, no drugs, alcohol, weapons, or guns while I'm bonding. That's all I ordered this time. All right, that'll be it. You can sign off, Ms. Jameson. That's the end of the bond hearing.
Thank you.
Mm-hmm.
Next, Your Honor, we got position number 9, Mr. Dudley.
This is 24 CR 003280J. Jamara Dudley, charged with 1 count of driving hit and run. Duty of driver to stop and return. Pre-trial.
Fourth arrest, 2020 simple battery, jail was the recommendation.
Okay.
Brief facts of the case is that on May 7, 2024, the officer responded to the incident location, which is 1195 Fairburn Road. In reference to a hit and run, the officer spoke with the victim, looks like Sparkle Hall, SparkleHall, who advised that her vehicle was struck by another vehicle. She provided a photograph of the vehicle's license plate and a photograph of the driver. She stated that the vehicle entered the parking lot and began to back up into a parking spot next to her vehicle. She advised that the vehicle struck her vehicle. She stated that at first, the defendant pretended to act as if he had not struck her vehicle. And then at which point he apologized and stated that she needed to do what she needed to do, I guess, before leaving the parking lot. She stated that the driver appeared to be under the influence. The officer also observed the collision on a video. Fortunately enough, our office was able to speak with Ms. Hall, who advised and confirmed the events in the warrant. She stated that her front bumper is dislodged. She stated that she did not get an estimate for the damage. She stated that she did, get an estimate for the damage and that it will cost her about $560 to repair the damage. I do believe that she's on the Zoom, so if we could sign for her in accordance with Marcy's law, that'd be greatly appreciated. Given the circumstances surrounding arrest, Your Honor, the recommendation from the state is a signature bond through the jail and a no alcohol, drugs, or weapons. And if we can sign for the victim, there's nothing further to add from the state at this time.
All right. And the victim in this case, her name again?
Sorry, Ms. Hall. The first name is going to be Sparkle, Sparkle.
Okay, Ms. Sparkle Hall. Are you on the call, Sparkle?
Yes, Your
Hall?
Honor. Yes, I'm here.
Okay, in order to speak with you, I need you to turn on your camera, your video.
Okay. Hello.
All right, raise your right hand for me. Do you wish to address the court today?
Yes.
All right, do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, 2 questions. Are you in fear of Mr. Dudley?
No.
Do you want to have any contact with Mr. Dudley?
No.
Okay, not in fear of him, but you don't want any contact, is that correct?
Yes, I do not know him personally.
Yeah, it's a hit and run case, Your Honor.
Oh, that's right.
Oh,
I'm
yeah,
sorry.
they're essentially
You just took a
strangers.
picture of the license
Yeah.
tag. I apologize. So you don't know him. And I get it. I
Yeah.
apologize. So good you got a copy of the tag. And so let's hear from his attorney and then I'll make a ruling. Mr. Cook?
Yes, Your Honor, my client is 45 years old. He has been employed for a number of years by Atlanta Tech. He denies the allegations as stated in the warrant. We would ask the court to accept the recommendation of pretrial, which I believe was a signature bond through the jail. Stayaways and contact, those are not really provisions that are particularly relevant here. So beyond that.
All right. Yeah. All right, that'll be a $2,000 signature bond through the jail. He is to have no further contact with the victim, Miss Hall. No driving without a valid license. And no drugs, alcohol, weapons, or guns while on bond. That should be it.
Next is gonna be position number 10, Mr. Santino Evans. Position number 10.
Okay. 24 CR 003258J, Santino Evans, charged with 1 count of unlawful conduct during 911 call. Retrial?
Fourth arrest, 2024 FTA. Got to open obstruction, reckless conduct in state court. On probation for terroristic threats in Superior Court. That's it.
All right, state.
Thank you, Your Honor. This incident took place on May 26, 2024. Law enforcement was dispatched to 1230 Murphy Avenue Southwest in Atlanta. The officer was advised by dispatch that Santino Evans had called 911 a total of 12 times over a 24-hour period. Mr. Evans was told on the 11th time that if he called 911 again, there was no emergency, he'd be going to jail. Mr. Evans did call 911 the 12th time, stated that he had chest pains and that he could not breathe. When EMS arrived, he told them that he was fine, did not need to go to the hospital. And the state's recommending a signature bond through the jail, whereas that Mr. Evans refrained from using 911 unless he's having an actual emergency. No alcohol, drugs, or weapons while out on bond.
All right. PD Cook?
Your Honor, we have no objection to the state's recommendation.
All right. And I'm assuming, again, with him calling, do we know the nature? We just kept calling 911 or?
Your Honor, the facts in the warrant is just that he repeatedly called 12 times over a 24-hour period, and that the last call was complaining of chest pains and that he could not breathe. But when EMS arrived, he said that he was fine and did not require any medical attention. And that was the 12th phone call, but no other details of the previous 11 phone calls.
All right. I will order a $1,500 signature bond through the jail. And Mr. Evans, please do not call 911 unless you have a genuine emergency, because when you tie them up like that, then they can't get to others who might be in a more immediate situation. But right now you will be on bond. And I think I said for 1,500, and you are not to call the 911 center unless you truly have an emergency at that moment.
Yes, ma'am.
Okay.
Yes, ma'am.
All right. And I think that'll Oh, no drugs, alcohol, weapons, or guns while on bond.
I can know.
All right.
I need position number 12, Mr. Harris, Demetrius Harris.
Hold for 1 second. All right, this is 24 CR 003261Y Demetrius Harris. Charged with 1 count of battery and 3 counts of cruelty to children in the 3rd degree. Retrial.
This fifth arrest, last was 06. Armed robbery, ag assault conviction. Level 2.
All right. State.
Thank you, Your Honor. This incident took place on April 6, 2024. Law enforcement responded to a physical dispute at a McDonald's location. It's at 7820 Senoia Road in Fairburn. Upon arrival, Tiffany McCall advised that she was meeting Demetrius Harris so that he could spend time with the child they shared together. Mr. Harris was upset because Tiffany had brought her mother, Sonia McCall, with her. After a verbal confrontation, the minor child, initials MM, was placed back into the car. Tiffany, her mother, Sonia, and 2 other children, initials IM and TM, proceeded through the drive-thru to order some food. At that time, Mr. Harris got out of his car yelling at both Tiffany and Sonia before striking Sonia in the face, causing bruising to her left eye. Of course, the 3 children were in the car. Those initials again are MM, IM, TM. They were all in the car and witnessed the incident. Your Honor, our office has spoken with Tiffany McCall, which is the daughter of the actual battery victim. She's the mother of 2 of Mr. Harris's children. She confirmed the events in the warrant. She stated that her mother would give our office a call back. She did sustain a black eye as a result of the incident. That nothing like this has happened before. The 2 of them have moved due to this incident that she's had some phone contact with him, but no physical contact, and her mother has had no physical contact with him. That this incident scared the two of them and the children, that they moved as a result. They would like no further contact and for him to stay away from their current residence. She indicated she will be on Zoom. Your Honor, due to the circumstances, the state's recommendation is a signature bond through pretrial services. We're going to ask for no further contact with Sonia McCall and Tiffany McCall. Stay away from their current residence, no alcohol, drugs, or weapons. And of course, Your Honor, if we can sound for Sonia McCall, Tiffany McCall, in accordance with Marcy's law.
All right, I see Tiffany, Sonia McCall on the screen. Do you all wish to address the court briefly today?
Yes.
All right, raise your right hand. Both of you. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hands down. I only hear from one of you because this is just a bond hearing. And I guess with Tiffany McCall, who's the mother of two of the children, do you want to have any contact with Mr. Harris?
Yes.
You do?
Only verbal.
Well, that's not contact, so verbal. Are you in fear of Mr. Harris?
No.
And then Sonia McCall is what relation to you?
She's my mother.
Yeah,
She
if
was
I
on the
may,
scene as well.
yes, so Miss Sonia McCall is the actual battery victim in this
Correct.
case.
Oh, and not Tiffany. I got them mixed up.
That's correct.
Okay. So Miss McCall, are you in fear? Miss Sonia McCall, are you in fear of Mr. Harris?
Can you hear me?
Yes. Are you in fear of Mr. Harris?
Yes.
Yes. You want to have any contact with Mr. Harris?
No.
Okay. All right. Anything cross-examination from the state or from PD Cook?
No, Your Honor.
Nothing from the state, Your Honor.
All right. You all may mute yourselves and I will hear from Mr. Cook.
Your Honor, given,
PD Cook.
yes, Your Honor, given the, we are aware of where they're now located. There has been some, I guess, telephone contact or some electronic contact. We have, given that, we have no objection to stay aware of the contact. That's not really relevant. There is a, we would ask you to accept the state's recommendation of a signature bond. Your Honor, there are children that are his. He would like, if possible, to have a third party transfer. We understand that can be difficult given the distance between the parties.
Well, I know that this incident happened back in April, and I'm assuming there's been no contact since April. Is that correct?
That is not correct. He has had contact with Tiffany McCall.
Okay, Miss McCall, have you had contact with Mr. Harris since April, since this incident?
Yes, ma'am.
Okay, for visitation or for what purposes?
Just verbal contact, video calls so he can see the children.
Okay, so no physical. These are just
Right.
been telephone calls and FaceTime.
Yes, ma'am.
Okay, so he's not had the kids overnight or seen them physically.
No, ma'am.
I got pictures. You have seen them?
I'm not here to belabor visitation schedule, anything like that. Were you all ever married?
No, ma'am.
Has he legitimated the children?
I'm not sure what that means.
Well, you would know if he's legitimated them. And they don't have his last name, so he probably hasn't. So
Oh, no,
that,
they don't have his last name.
All right. I'm not gonna order visitation at this time, but I will, let's see. It's gonna be a $5,000 signature bond through pretrial, 2,000 on the battery, 1,000 on each of the 3 cruelty charges, for a total of 5,000. Signature bond through pretrial. And I'm gonna require him to take a 2-day anger awareness course through pretrial, which is free. And I believe he was level 2. So he'll have to report in and they'll explain that to him. No drugs, alcohol, weapons, or guns while on bond. And I'm going to continue with the verbal visitation only, no physical while on bond, so he can continue to call them or FaceTime as you've been doing. I'm not going to order any third-party transfer. I'm not going to get into that. He needs to get a court order if he wants to have visitation and legitimize the children. That's a whole different ball of wax there. And I'm going to order stay away from your residence. I'm going to order and no further contact. I think that's what you've been under so far, correct? You haven't had any physical contact with him, and you stated you've been in fear of them, so I've allowed him to at least talk to the children. But I didn't want to do the no further. I'm sorry.
His position is they have had physical contact.
The children are the parents and grandmother.
The mother.
And she says no.
I can prove it, Your Honor.
But I'm not here for that. I'm here to make sure everybody's gonna be safe. So what I'm going to order, and if you had contact with her, was it to visit with the children?
She recently came down to move some things out the storage. So that's when we met up. I got some things out the storage. I kicked it with her the whole night, talked to her the whole night, was with her the whole night. I'm talking about the whole night. She had, it's no fear with her. She already said that it's the mother.
And Your Honor, if I may,
and please,
Hold on, Mr. Harris. Yes, go ahead.
The charge is a battery against Sonia McCall, and then the cruelty charges are related to the 3 children. So the state's recommendation is in line with Your Honor's. No further contact, and I guess if the video call is sufficient, the state has no objection, but I don't think that it's relevant, whatever contact they've had since then. And we would also like to add no alcohol, drugs, or weapons, Your Honor, onto the bond conditions.
Right, no drugs, alcohol, weapons, or guns while on bond. I'm trying to make sure if I order no further contact with Sonia McCall, which is the grandmother, definitely don't want him having contact with her because she sustained the injuries, correct? But in regards to Tiffany McCall, I don't know if it should be no further violent contact, but the problem is in order to do FaceTime and call his kids, he doesn't need to see her. And if they went to a storage bin and met up, I thought he was going to say they met up to have visitation with the children, but that's not the case.
Your Honor, can I speak, please?
No, I just want to make sure everybody's going to be safe.
Your Honor, may I speak?
Yes.
Okay. I feel like that my life was endangered by him assaulting me when I never once said anything to him. And also, I have fear for my daughter and all of my grandchildren. And by me being the matriarch of this family, I am looking out for them. Now, his behavior is unacceptable. No bad deed goes unpunished. I don't wish no harm or anything on this young man. I will pray for him. But on behalf of my family, I have to protect them. And I ask that you guys do whatever is necessary on his behalf for the justice to be served.
Now, Tiffany, can you please say something?
And Your Honor, I'll just reiterate.
No, Mr. Harris, please don't say anything else and don't speak to the victims. Yes,
This
Mr.
case
Graham.
involves Miss Sonia McCall and the 3 children. As you said, if Mr. Harris wants to make a legitimation action, he can do that in another venue. Here's the bond hearing. The state's recommendation is that he has no further contact with Sonia McCall or Tiffany McCall or the 3 children, and stay away from the residence, no alcohol, drugs, or weapons. Signature bond through pretrial services was the state's recommendation. Level 2, we're fine with, and nothing further from the state, Your Honor.
Right. I'm going to order no further contact right now to make sure there's no intimidation by Mr. Harris with Miss Tiffany McCall. And I'm going to find the testimony of the grandma, Sonia McCall, to be pretty credible. So Miss Tiffany McCall, I need you to stay away. Make sure that that things have kind of blown over or gotten better, even though it's been about a month. I think you need some time off and a break and some distance to make sure that everyone's thinking clearly and that you're going to be safe in the future.
I believe
So that is my concern. I'm not speaking to you, Mr. Harris, and I've given a ruling, so please don't interrupt me. Don't interrupt me. I've not asked you to speak. And so I want to make sure that everyone's going to be safe going forward and not intimidated. And so right now, while this bond is going on, I want there to be no further contact with any of the victims, the mother, the daughter, and the children. But with the children, I'm going to allow FaceTime and phone calls. How old are the children?
My 2 sons, he'll be 1 June 13th, and my son, Makari, he'll be 2 in August.
They're 1 and 2?
They're 11 months apart. So my
No,
son's
what I
already,
meant was they're very young. I was thinking we
oh,
maybe talking
yes.
about 4 or 5, 6-year-old. So they can't really talk that much anyway. They're just looking at him and listening to him. And so all 3, so the 2 by him are 1 and 2 years old.
Yes, ma'am.
Okay. So no, he doesn't need to have any physical contact with them. They're too young anyway. And so at this point, just let him FaceTime and talk to them for how many ever minutes that is. Usually 1 and 2 year olds are not going to be on the phone that long anyway. And continue that. I don't want any physical contact. And you know, Mr. Cook can file for an amendment later if things change. All right.
All right. Thank you, Your Honor.
Thank you.
Next, Your Honor, we got position number 15, Mr. Jefferson.
This is 24 CR 003288G to Quaylen Jefferson, 1 count of simple battery.
First arrest, resident of Texas. Jail is the recommendation.
Okay. Okay.
Thank you, Your Honor. This incident took place on May 24th, 2024. Law enforcement responded to a domestic dispute at 1750 Commerce Drive Northwest in Atlanta. Taquaylon Jefferson did strike Jalacia, Jalacia Whitmore with a closed fist. He grabbed her by the neck and threw her into the bedroom door. He then grabbed her by the hair and was dragging her from the bedroom to the bathroom. He placed her head in the tub, began to run water, causing her not to be able to breathe. Your Honor, the warrant was not very detailed, and we have requested the incident report. We're still waiting for that. Even though it's unclear whether or not there was standing water in the bathtub when he put her head in there, or if he was just running the faucet over, we are concerned for Miss Whitmore's safety, the fact that she was underwater and unable to breathe. And we may consider a transfer upon gathering additional details in the case. Our office has not been able to get in touch with Miss Whitmore. But Your Honor, based on that, even though this is his first arrest, the state is requesting a $2,500 surety bond, 1-day anger awareness course, no further contact with Jalacia Whitmore, stay away from 1750 Commerce Drive Northwest, no alcohol, drugs, or weapons. And of course, if we can sound for Ms. Jalacia Whitmore at this time, Your Honor.
All right, Jamacia Whitmore. Jamacia Whitmore. I don't think she's on the Zoom. All right, go ahead, PD Ajay.
Yes, thank you, Your Honor. My client is 20 years old. He has graduated from high school and he is gainfully employed as a security guard with Allied Security. As you heard from pretrial, this is his very first arrest. He's never been arrested before. I have not been able to get in touch with the complaining witness. My client firmly denies the allegations as stated in the warrant. I would ask for a I object to the $2,500 surety bond. This is his first arrest. I would ask for a signature bond through the jail since it is his first arrest, and no further contact with the complaining witness, and a stay away is fine. He would need a one-time law enforcement escort to go back to that location, which is an Airbnb, to collect his things that are there. And nothing further, Your Honor. I just want to emphasize that he does firmly deny the allegations as stated in the warrant, and states that he did not touch her at all.
And so if he's a resident of Texas, does he have an address here? Because the Airbnb may be gone by now.
He doesn't have an address, Your Honor, but he does work. He is able to return to court for any future, in the future.
He works in Georgia or Texas?
No, Your Honor, he lives in Texas. They were here for a birthday trip. They were both visiting, and they don't live together in Texas. They live about 5 hours away in Texas, and he's again fine with the stay away and no further contact.
Okay. All right, I will order a 2,500 signature bond through the jail. And I assume he will be back for court. And with that $2,500 signature bond through the jail, I'm going to order a stay away from the residence of the victim as well as the Airbnb here in Georgia. I guess he won't be going back there. I'm going to order no further contact with the victim to make sure that she is safe. No drugs, alcohol, weapons, or guns while on bond. That's it.
Your Honor,
Yes.
he wants to know if he can Zoom call his court dates since he lives in Texas.
I doubt it. I wouldn't know about that at this point. It would depend when they're set and whether there's an option. It's possible, but I can't guarantee that. I cannot guarantee that. He may need to start saving up so he can get transportation to get back to Georgia in person. I don't know.
Next, we're gonna go to position number 16, DeAndre Jenkins.
Okay. This is 24 CR 003263Y, DeAndre Jenkins, charged at 1 count of battery family violence. Pretrial.
Fourth arrest on probation in the cab for stalking. Yeah, last arrest was for trespass and that stalking. 2021 trespass dismissed. 2020 disorderly conduct conviction.
Okay. Date.
Thank you, Your Honor. This incident took place on June 10th, 2023. Law enforcement responded to a domestic dispute at 349 Decatur Street Southeast in Atlanta. Taryn Singh, that's Taryn, last name Seng, advised that her ex-boyfriend DeAndre Jenkins was upset when he walked into the apartment and she was talking on the phone with a friend. He began throwing items around the apartment and toppling furniture. When he got close to her, he hit her with an open hand on her chin. Then he repeatedly grabbed her before she was able to break free, leave the apartment, and seek refuge with a friend in another apartment. Ms. Singh sustained bruising on her arm. She had a laceration on the inside of her mouth as a result of the attack. The two were living together at the time. Our office has been in touch with Ms. Singh. She says they are no longer in a relationship. They no longer live together. They share no children. She confirmed the events in the warrant. She stated that he has grabbed her in the past, but this was the first time he had hit her. She no longer lives at the incident location. She has not had any contact with him since this incident, does not wish to have contact, that she'd be unable to attend the Zoom hearing today. Your Honor, based on the history, the state is recommending a $5,000 surety bond. We're going to ask for no further contact with Terrence Singh. Your Honor, there was a stalking conviction out of DeKalb in October of 2023. As a part of those conditions, there was evaluation and treatment that was ordered. So the state is asking that he remains compliant with any treatment plans. We want to ask for a stay away, but no alcohol, drugs, and weapons while out on bond. And if we may sound for Terrence Singh at this time, Your Honor.
And what was your recommendation again?
I'm sorry, Your Honor, $5,000 surety bond, no further contact with the victim, compliance with any treatment plans that may be in place, and no alcohol, drugs, or weapons.
Okay. All right, Terrence Singh. Singh. Nope. All right. Oh, PD Atai, I'm sorry.
Yes, Your Honor, my client is 29 years old. He has lived in Georgia all his life. He is a high school graduate. He has worked for the last 2 years at McLean Co. in their warehouse. He does deny the allegations as stated in the warrant. This incident allegedly occurred June of last year. They have not had contact in about a year since that time. So we don't object to the no further contact and a stay away. There hasn't been contact for almost 1 year. I mean, he has some history, Your Honor, but stalking and criminal trespass, I don't believe that a $5,000 surety bond is reasonable in this case, Your Honor. It happened almost a year ago, and he does deny the allegations as stated in the warrant. So I would ask for a signature bond, and it can be through pretrial services. He is recommended for a signature bond through pretrial services at level 1. So I'd ask for that. And then, of course, the stay away and no further contact, as they have been doing for the last year. Nothing further.
Okay. I will order a $4,000 signature bond through pretrial at level 1. And with that 4,000 signature bond through pretrial, stay away from the victim's residence. No further contact with the victim. I guess they've been doing that. And to comply with any treatment plan previously ordered. In the other case, no drugs, alcohol, weapons, or guns while on bond.
This is per judge.
Per judge. All right, next.
It's gonna be position number 17, Mr. Kennedy.
All right, 24 CR 003264F. Marcello Kennedy, charge of 1 count of battery, family violence. Pretrial.
6 total, 2022 kidnapping, dismissed. 2016 probation, 14 FTA, and 13 robbery first offender.
Okay. State.
Thank you, Your Honor. This incident took place on May 25th, 2024. Law enforcement responded to a dispute call at 3100 Godby Road. It's apartment 215E in College Park. Upon arrival, the officer observed Marcello Kennedy and Kenyara, it's Kenyara, Rogers, outside yelling at each other. Miss Rogers advised that when she attempted to lie down in the bed next to Mr. Kennedy, he became angry. He elbowed her in the mouth. The officer did observe a contusion on the inside of her lip and that it was bleeding. She further advised that the two have been in a romantic relationship since last year and that they've lived together since then. Your Honor, we would like to point out that the victim in this case is 17 years old. There's a 12-year age difference between she and Mr. Kennedy. The state is gravely concerned for her safety, especially at the young age, and we feel like she's at risk of ongoing abuse. We have not been able to get in touch with her at this time, Your Honor, and based on the history and the nature of those allegations, the state is recommending a $5,000 surety bond, 1-day anger awareness, no further contact with the victim. We're also going to ask for a stay away from the incident location, no alcohol, drugs, or weapons while out on bond, and if we may, song for Ms. Kenyara Rogers at this time, Your Honor.
All right, Ms. Kenyara Rogers. Ms. Rogers. All right, go ahead, Peter, your time.
Yes, Your Honor, my client is 29 years old. He is a Georgia resident. He is the father to 3 minor children, 2, 4, and 5 years old. Those children are, of course, not shared with the complaining witness. As I saw that the recent case was dismissed and he has history, but it's from more than 8 years ago. And pretrial, correct me if I'm wrong, but the report that I got from pretrial states that he's recommended for a signature bond through the jail. So I do think a $5,000 surety bond is excessive. Your Honor, he does deny the allegations as stated in the warrant and tells me that he's the one who called the police. He has marks and bruises. She wouldn't let him leave the location. And Your Honor, the warrant states that he was in the bed and she came there and, I mean, he was asleep. So he denies the allegations as stated in the warrant. So I would ask, as he's recommended, for a signature bond through the jail. I haven't been in touch with the complaining witness, so no further contact and a stay away. I don't object to that.
I do have some concerns, I guess, with the age difference and I guess the victim is still a minor, 17.
I believe the age of consent in Georgia is 16, Your Honor.
True, but
I was lied to by her age one time. And I was
Mr. Kennedy, you have a right to remain silent. Your Honor, he is gainfully employed. He works as a head cook at a restaurant and is worried that he may have lost his job. He was arrested on May 25th. And again, he's recommended for a signature bond through the jail.
all right, I'm going to order the $5,000 signature bond through the jail. I'm going to order a stay away from the 3100 Godby Road in College Park, which I assume is the residence of the victim.
No, Your
Or
Honor,
is it not?
that's his home, Your
His residence, but you said she came to his. So he needs to stay away from her residence, wherever that is. Be
Well, Your
200
Honor,
yards away from her.
according to the warrant, they live there together. So I do believe she lives at that residence. Even if she moved in with him, that's where she's living.
I would think she has a family to return to at 17 years old.
I would hope so.
Possible,
So
but
I'm
she's
just
the victim in this case, and that's where she resides. So that's the reason for the state's request. We're happy to allow for one-time police escort to make sure she doesn't live there, but if she does, stay away is what we're requesting, Your Honor.
All right, I will allow him to return to the residence with a police escort. And once they sweep the location to determine whether the victim still resides there. But I don't know, does she work at 17? Does she have a job and can she afford the rent? I mean, it's kind of a different situation than we've had and she's not even 18. I don't know, she could still be in high school. Sounds like an interesting situation to me. And, you know, I usually don't put the victims out, but I mean, he would still have to pay rent for her to stay there. I want him to have no further contact with her, and we haven't spoken to her, so I don't know what she's thinking, or she just in fear and hiding out. I don't know. But my duty is to protect the victim, make sure that she is free of any intimidation or other harm. Let's do a sweep of the residence by law enforcement. He cannot go back alone. He needs to have a law enforcement escort. If they determine that she still resides there, if she can reside there, I guess she will, and he needs to stay away until she moves out or goes back home. And if she's residing there, he cannot reside there. No further contact between the parties. I'm going to order no further contact. I don't know what's going on, but my gut tells me it's not good. So no further contact with the parties while on bond, no drugs, alcohol, or weapons while on bond. And so let's see where we go, or maybe it'd have to be a bond modification here. But let's see state if we can try to reach this victim. All right, that's it, deputies.
Next, we have position 21 and position 20 and position 21, Mr. Mitchell.
All right.
Judge, position 21.
Your Honor, we may need to hold this one till the end.
Okay. Can we hold this one?
And just to be clear, there's two positions on the calendar, but I think it was just a typo. There's only one case.
Oh, for this defendant? Oh, I see it is
Yes.
twice.
Mm-hmm.
It's 20 and 21.
Yes, Judge.
Mr. Jordan, it's just a typo.
That's
Yeah,
correct.
it's just the same case number, so.
Okay.
So what are we doing, Your Honor? We're gonna put them to the end of the calendar?
I would like to, if you're able to do that.
Okay. You go to the third one. So next we'll go to position number 24, Mr. Timothy Fall.
Okay. This is 24 CR 00328815, Timothy Quarries, charge of 1 count of battery.
Third row. Yeah. Third row.
He's on probation, ag battery out of Superior Court.
Yes.
2022 probation, 2018 battery conviction, 2018 FTA. Couple of arrests from 2013 for assault and battery convictions.
How many cycles?
I didn't write them down.
I
That's why I
have
skipped
seven
it.
cycles.
Seven
cycles out of
Okay.
Virginia, Your Honor, 9 cycles out of Georgia.
Thank you.
And Judge, this incident took place May 6th, 2024. Officers received their reflection student housing at 111 John Wesley Dobbs Ave Northeast, and specifically apartment 1504, and to a dispute. Upon arrival, the officers made contact with the victim. Her name is Haley Van Heydricht, who stated that the defendant slammed onto the ground and punched her in the face, causing her mouth. The warrant says that she had bruised lacerations to her lip. Our office has been in victim. She will not be on Zoom today. She actually had to go to the hospital because of the injuries from this. She stated that she and the defendant are friends. They've known each other for about a year. He is struggling to find a place to let him stay with her for a day. He tried to get the same bed with her, and she told him no, and he got upset and started hitting her. She says that if the police had not come, she believed that the defendant was going to kill her. She's at the hospital today. Her whole body is sore, having trouble walking. She wants a no contact and a stay away. In light of that, in his record, Your Honor, the state is recommending a surety bond, a no further contact with the victim, a stay away from the incident location, 2-day anonymous, no weapons, drugs, or alcohol while out on bond. I don't expect the victims here, Your Honor, but if Your Honor could sound for her at this time, her name's Haley Van Heydrich.
Haley Van Heydrich. Heydrich, are you on? Nope. All right. Whose case is this?
It's my case, Your Honor.
Oh, hi, how are
And
you?
I'm well. Just a brief correction. The defendant's last name is Quarles. It's not an I, it's an L. It's mistyped on everything, but his last name is Quarles.
Okay.
With that being said, Mr. Quarles is 30 years old. He just recently lost his job. He does deny the allegations in the warrant, specifically because he states that she initiated the violence by hitting him with a water bottle filled with wine. And he does not, because he has lost his job, he will not be able to pay a surety bond. So we are asking for a $4,500 signature bond, nothing further.
All right. I'm going to order the $2,500 surety bond. I'm going to order no further contact with the victim. And I guess there is stay away from her residence, wherever that is, because that's not the incident location. It's his place, right? So I don't know if we
No,
have
Your Honor, the
her.
incident is her residence.
Say that again. Your mouth is moving different from you, so I'm getting like every other word, but I'm able to make it out. Say that again.
I'm sorry, I'm on two different devices, Your Honor. The incident location is her address, not.
Oh, okay. So is to stay away from the incident location, no further contact with the victim, no drugs, alcohol, weapons, or guns while on bond.
Your Honor, what was that bond amount? I apologize.
2,500 surety.
Thank you.
Uh-huh.
And Your Honor, if you would consider a 2-day. He does have a prior battery from Georgia, and then also 2 prior batteries from the state of Virginia.
And I heard you say if I would consider a 2-day what?
Anger awareness, Your Honor. Because of his record, he has 3 prior batteries.
I know, but he just lost his job. How's he gonna pay for it? I would love to order it, but I don't do it unless we go through pretrial for them to get it free. Yeah.
Next, Your Honor, we're going to go to position number 25, Mr. Christopher Small. Oh,
Okay.
one
What was
second.
that? What was the last bond amount?
2,500 surety.
Thank
you. Give me 1 second, Your Honor, so I can get them out.
Okay.
This is position number 25, Mr. Christopher Small.
All right, this is 24 CR 003285G. Christopher Small, charged with 1 count of simple battery, family violence, 2nd count of criminal trespass and damage to property.
Second arrest, 2011 probation, level 1.
Your Honor, this incident took place May 2024. Officers responded to a dispute at 38 Chappelle Road in Atlanta. Upon arrival, the officers made contact with the victim, Middlebrooks, who advised she and her child's father, who's dependent, were speaking around 4 a.m. that morning about coordinating pickup for their daughter to be dropped off at school. She asked him to be there by 6 a.m. so the daughter could be on time. 6 a.m. came and went. The dad picked up the child. So she had to take the child. The dad showed up at the house after the daughter was already at school. Was upset because he had wasted coming over there. He slapped them across the face. He tried to enter the residence. The victim and the party's older child held the door so that he couldn't get in. And then he threw a glass fishbowl at the door, damaging the door. The victim did have no injuries. Our office has been in touch with her. She said that they do not live together. They have children. There is a DV history throughout the relationship, but it was never reported. Feels like the defendant has MH issues. She is in fear of him unless he gets help. She confirmed the events in the warrant. She stated that she wants no further contact, anger awareness, and MHET and parenting classes. Your Honor, I understand that she's contact, but given what the victim has told our office, there is a concern for her safety. The state is recommending a signature bond through the jail, a no further contact with them, a stay away from the incident location, awareness, MHET and recommended treatment, and no weapons, drug, alcohol out on bond. And if Your Honor could sound for Miss Pauline Middlebrooks, who's on the Zoom.
Okay. Pauline Middlebrooks.
Yes, ma'am.
Okay, do you wish to address the court today?
Absolutely.
Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Put your hand down for me. Are you in fear of Mr. Small?
No.
Okay, do you want to have any further contact with Mr. Small?
Yes.
Okay. All right, that's all the questions I have. Any cross-examination by the state or the PD?
May I address the court?
Hold on a second. No. State or PD?
I have a
Holly,
few questions.
Okay.
Your Honor, you swear her in?
I did. Mm-hmm.
Okay, I'm sorry. Ms. Middlebrooks, did you call the police?
Yes.
And you previously told our office that you believe that your ex has some mental issues and you'd like to see him get help for those?
Correct.
And is it true that you told our office that you are in fear of him if he doesn't get help?
No, I didn't say I was in fear of him. I said I want him to get help, but he does need help.
Okay, and you guys have a history together as far as domestic violence goes. Would you agree with that?
To some extent, yes.
Okay, can you elaborate what you mean when you say that? What kind of history are you referring to?
I mean, we've lived together before. And
has he hit you before?
Yes.
And did he injure you?
Yes.
Has he been violent with you in front of your children? And has he been violent to your children?
Yes.
Nothing further, Judge.
All right, go ahead, PD Holly.
Yes, Your Honor. I think it's important to clarify a lot of what's in the warrant. The police actually made contact with my client first because both of the parties called the police after this incident. And my client was actually the only person who had visible injuries. He had a busted lip. And his side of the story is that he went over to pick up his daughter. And when he was called into the house, he was actually jumped on by the complaining witness and her older daughter. And he did have visible injuries. He denies initiating any type of physical altercation with them. As the state said, there were no injuries to Ms. Middlebrooks at all. I do not suspect that there are any mental health issues in this case. I know that the recommendation is a signature bond. Obviously, we are okay with that. I'm fine with 1 day anger awareness, and we would just ask the court to go forward on the signature bond as recommended.
And Your Honor, just a brief response to that. The police were aware that he did have injuries and they determined that he was the primary aggressor.
Okay, how old is Mr. Small?
Say that again, Mel.
How old are you?
I'm 36 now.
Okay. And one last thing, PD Holly, is Mr. Small working?
He does work. He works for One Flew South. He at the airport. and he has a good, solid job. And as I stated before, he does have a child here as well, who he helps care for. Obviously, I understand that there's going to be some type of no contact order. He's okay with no further contact, but we would like a third party statement so that they can still exchange the daughter.
Okay.
May I still address the courts?
Let me ask you a question first, Miss Middlebrooks. So, with your daughter, how old is the daughter that you have with Mr. Small?
5.
5. And has he legitimated the child, or does he have a visitation schedule?
We go for legitimation, I believe next month, but I objected to it.
Oh, so he has filed for legitimation, it's just still pending.
Correct.
Okay. And since this incident, have you all exchanged the child, or have you allowed him to have visitation?
That was Friday, so he's been in there since Friday.
No, he hasn't. But prior to that, you all were exchanging her for visitation?
Yes, on my discretion.
Okay. And is his legitimation case pending here in Fulton County?
Yes, ma'am.
Okay. Okay. Well, I'm inclined to rule. I don't know what else you to tell me. This is a bond hearing. This is not your ultimate hearing in the case at all. It is just to determine bond and to make sure that you and your daughter will be safe while he's out on bond.
Right. And I was asking that when I spoke with someone earlier that gave me the information for a court, I was asking for no stay away. She asked me, did I want to stay away? And I said no.
Okay. Well, this is still a little, as I call it, a little fresh, and to make sure there's been the ample cooling down period. And that you and your daughter will be safe. We don't want any more incidents. And sometimes you need some time apart to cool down.
We've spoken since then.
You spoken to him on the jail phone?
Yes, ma'am.
Okay, well, I still need him to get out and make sure he's going to do what he needs to do, so that there won't be any other incidents. And
Your Honor, they don't live together. He doesn't live at the location.
right. And so that's fine. I will give him a signature bond. Let's see, on the simple battery, 2,000, and on the criminal trespass, 1,000. So that'd be a $3,000 signature bond. And I will, I know he was recommended for level 1.
That's what I was saying. I didn't fear because he needed assistance with getting his belongings and all of that. And he requested that I do that. So that's why I said I didn't want the no contact thing.
Well, if there was no contact, then he would have a police escort to come and get his personal belongings.
No, I'm saying for his property and his vehicle.
From your residence?
No, he wanted me to pick him up to take him to get his belongings. But that's what I was saying.
And where are they?
Property and where y'all hold the property at.
Oh, you're talking about from, oh, I thought you meant a location. I apologize. I that went totally over my head. You're saying he wants your help to get his items out of impound.
Correct.
Okay. Well, I mean, you can, I don't know that you have to go with him to do that. So I guess if
Your
you're
Honor, he
not,
could
if
easily
you're
find
not in fear of him,
person to help with that.
I'm sorry.
Your Honor, I think that he could easily find another person to help retrieve his property.
Nobody else was willing to, but I'll put it back on mute.
Right. If that's the only reason you want to have contact with him is to help him get his property out of impound, that
No,
doesn't
so you
sound.
see his child as well.
To see his child. The
Mhm.
child is 5 years old.
And she's a daddy's girl.
Excuse me.
Yeah, but the problem is I don't want to have any more incidents, and this one just happened a few days ago. So I don't know what went south on that, but I don't want it to go south again. So I just want to make sure that you and your daughter are going to be safe. But you say you're not in fear of him and you want to still go around him.
Correct.
Okay. I'm going to give him a $3,000 signature bond through the jail. 2,000 on the battery, 1,000 on the criminal trespass. And
It's through the jail, not pretrial?
oh, he was recommended for pretrial level 1, wasn't he? Is that what the state, was that the recommendation?
Your Honor, due to the circumstances of the arrest, the state recommended a signature bond through the jail.
Oh, okay, through the jail. All right, so it'll be through the jail. And he's to have no further violent contact with the victim and her daughter. He is to have no guns, drugs, or alcohol or weapons while on bond. And since he is working, I'm going to order him to take a 1-day anger awareness course at his cost. All right, so that's all I'll order at this time.
Next, Your Honor, is gonna be position number 26, Mr. Trayvon Smith.
And Ms. Middlebrooks, you're free to go as well. Thank you. Trayvon Smith, 24 CR 0032886C, charged at 1 count of battery family violence. Pretrial.
7 total. Last arrest was out of Douglas County. 3 counts of ag assault, false imprisonment, 2 counts of battery DV, violation of family violence order. I think those are dead docket. Last arrest was 2024 for FTA, but he did have that in Douglas. 2014 simple battery, dismissed. 2017 simple possession. This was level 2.
Okay. State.
Your Honor, this incident took place on November 25th, 2022. Officers responded to a fight call at 410 Lake Dillon Court in Fairburn. Upon arrival, the officers made contact with the victim, April Winston, who advised that she and the defendant were in the middle of a breakup and she packed up his things for him to move out. The dispute escalated, hit her in the head with a clothes hanger, and then began punching her repeatedly with a closed fist to her face and stomach areas while she lay in position getting beat up. The officer bruising and lacerations to the victim's face and body. Our office has not been in touch with the victim, and the state's recommending a signature bond trial and no further contact with the victim away from the incident location. FEIP, no weapons, drugs, or alcohol while out on bond. And if we could sound for April Winston.
All right, April Winston. April Winston. All right, go ahead, PD Holly.
Yes, Your Honor. So as the state mentioned, this case, the incident date is November of 2022. So it's over a year and a half old. They have had no contact since they broke up. There hasn't been any issues. I don't have any problems with any of the conditions on the signature bond other than the FVIP. That's a course that costs nearly $700 and takes 6 months to do. We would ask for 1-day anger awareness instead.
Okay. And is Mr. Smith working?
He does work. He has a CDL.
All right, I will order a $2,500 signature bond through the jail. I'm going to order a stay away from is it 410 Lake something Drive? From her residence, I guess. No further contact with the victim, April Winston. And he can take a 1-day anger awareness course of his choice and cost. No drugs, alcohol, weapons, or guns while on bond. Okay.
Next is gonna be position 27, Mr. David Salas.
This is 24 CR 003287Y, David South, charged of 1 count of willful obstruction of a law enforcement officer and giving false information. Retrial.
Second arrest, 2020 has some CWAC charges. Appears to still be open, 21 SC 178738. Jail is a recommendation.
States.
Your Honor, this incident took place May 25th, 2024. Officers responded to 879 Gap Street Southwest regarding a male with a gun loitering. Upon the officers met with the residents at the location. Officers initially went to one of the homes and the neighbors refused to give their name and said they didn't call the police and it was probably the neighbor. However, before the officer could interview any other neighbors, they saw the defendant fleeing from the scene. While the defendant was fleeing, he dropped a camo-colored gun. Police pursued him for several blocks, running through yards, hopping over fences. In the pursuit, the other neighbors were out saying that there was a man that was prowling in their backyard. He was finally apprehended and he gave the officers the false name of Terrell Watts. Judge, he does have an open felony case. Just want to be clear that it is a C charge. He also has aggravated assault, strangulation, 2 other forcible CWAC charges, battery, hindering a person making an emergency call, and criminal trespass. For that case, Judge, he was actually denied bond 4 times. The court finally gave him a bond of $70,000, and then he was in jail for probably another 6 months or so before the court reduced the bond again to about $30,000. Part of that bond was he was supposed to not have any firearms. He was also supposed to be out on an ankle monitor. There's no wearing ankle monitor in the warrant or the report that I've read. He has an FTA from that case. He had private counsel and he failed to appear when his case came up for a jury trial. So why he was out without his ankle monitor and with a gun in a neighborhood just hanging out where he didn't need to be is very concerning for the state, considering the yellow fact. He's a danger to the community. He's certainly a flight risk. His open case is very egregious. He's not complying with the bond, as I just said. He had a weapon. Thank goodness 911 was called when it was. Nothing else happened. He's certainly a flight risk. He was trying to evade police. And he didn't show up for his felony case. So in light of that, the state is recommending a $10,000 surety bond on the obstruction, a $500 surety bond on the giving false name, a stay away from the incident location, and no weapons, drugs, or alcohol while out on bond.
All right.
Your Honor, Mr. South is 23 years old, and there are allegations in the felony case. However, those are not convictions. And he has not been convicted of any of those charges. He is currently self-employed. He does landscaping and he does live in Decatur. Your Honor, I have concerns about the mechanism through which this case was initiated. I'm not sure that someone, as the state put it, just hanging out is reason for the police to be called or pursue someone who left the scene. However, with that being said, he is recommended for signature bond, and we are asking for one.
And Your Honor, to be clear, the report says that they responded to a person with a gun loitering. And I believe that's what I said.
Mr. South, just remain silent.
I just said one thing.
I don't think you should.
I don't recommend it.
Okay. Given these charges versus his history, I was not inclined to do a signature bond, but he's recommended. Assuming he's coming back to court, but I'm not, don't like what I'm hearing, but I will give him a $7,500 signature bond through the jail. That'll be $500 on the obstruction. I'm sorry, $5,000 on the obstruction and 2,500 on the false names. It's a total of $7,500 signature bond through the jail. No drugs, alcohol, weapons, or guns while on bond. And was there a stay away request or no?
Yes, Judge.
Stay
It would be
away
a stay away from. It was an address in a neighborhood, Your Honor. I have 879 Gaston Street. I tried to look up. It's not a subdivision of any kind. It's just a street with single family residences. So I would
Okay.
ask for a stay away from all of Gaston Street.
Okay, stay away from that street. And what else was the state requesting?
No weapons, drugs, or alcohol out on bond.
Okay, and no alcohol, drugs, weapons, or guns while on bond. All right, 7,500 SOB jail.
Good. Next, Your Honor, is going to be position number 29, Mr. Brian Stevenson.
This is 2400, 24 CR rather, 003275F. Ryan Stevenson. Charged at 1 count of battery family violence. Sorry, 2 counts of battery family violence, 1 count of criminal trespass, and 1 count of theft by taking.
2021 ag assault, cruelty in the third. That's out of Cobb County. 2019 possession of marijuana NOLO and probation violations in this history.
Okay. State.
Your Honor, officers responded to 6803 Kimberly Mill Road, South Fulton, in reference to a fight call. One of the victims, Miss Chamere Butler, who shares a child with the defendant, stated that they had gotten into an altercation regarding Miss Butler not getting the defendant a water. The defendant grabbed Miss Butler by the neck, which caused bruising and lacerations. Upon hearing the commotion that was taking place, Miss Butler's daughter, Chamaya Winfrey, came upstairs to try to defuse the situation. The defendant then began pushing Miss Winfrey and then began striking her in the face with a closed fist, which caused scratches and bruising to Miss Winfrey. The defendant then stole Miss Butler's car keys and broke Miss Winfrey's Samsung phone. All parties reside in the same residence. Our office has had a chance to speak with the victims. Miss Chamere Butler stated that the parties do not have a DV history. She is not in fear of the defendant. She did confirm the events in the warrant and stated that things have been okay since the defendant returned her keys and replaced the broken cell phone. Ms. Chamaya Winfrey agreed with her mother and stated she's not in fear with the defendant. Both victims did state that they want contact with the defendant and for the defendant to return to the residence. However, given the defendant's history, the state is recommending for the battery family violence, a $2,500 surety bond. For the second battery family violence, another $2,500 surety bond. For the criminal trespass, a $500 surety bond. And for the theft by taking, a $500 surety bond, which is a $6,000 surety bond in total. No further contact with either of the victims and to stay away from 6803 Kimberly Mill Road in South Fulton, and no drugs, weapons, or alcohol while out on bond. At this time, I will sound for both victims, Miss Chamere Butler and Chamaya Winfrey.
Butler and Miss Winfrey. Don't think they're on.
Miss
PD
Butler, I see, is
Oh.
on the call.
Where is she? Oh, I see. Miss
I don't know
Butler,
if she wants to speak.
do you wish to address the court today, Miss Butler?
Yes, ma'am. I was trying to get on.
Okay.
Yes, ma'am.
Okay, I have to see your face.
I'm trying to get it up. Okay, I'm here. I'm at work, so I have to get to a clear spot.
All right. Do you wish to speak briefly to the court today?
Yes.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, are you in fear of Mr. Stevenson?
No, ma'am.
You want to have contact with Mr. Stevenson?
Yes, ma'am.
All right. And then the other person, was it your daughter or your mom?
My
Which-
daughter.
Your daughter. Okay.
Yes, ma'am.
And you all reside together?
Yes, ma'am. We all stay together in the same household. Yes, ma'am.
But Mr. Stevenson he's not the father of,
Not Shemaiah, but he the father of my 7-year-old.
you all have a 7-year-old together?
Yes, ma'am.
Okay. All right. I don't have any further questions. Anything from the state or from the PD's office, any cross-examination?
Yes, Your Honor. Ms. Butler, the defendant has a 2013 aggravated assault family violence charge that was pleaded down to simple battery. Were you aware of this charge?
Yes, ma'am.
Were you the victim in that case?
My daughter. Yes, ma'am. Yes.
You were the victim in that case?
Yes.
Okay, thank you. No further questions, Your Honor.
All right. PD Holly, you can mute yourself, Ms. Butler.
Okay, thank you.
Thank you.
I got it. Hold on. Give me a second. I got to get it together.
Yes, Your Honor. This did happen back in October. The parties have been living together for over 8 months since this incident. I'd also like to state that the parties are engaged and they have been going to marriage counseling together to improve their relationship. As she stated, they do have a 7-year-old together. And Mr. Stevenson is 43 years old, and he does work at ResNet as a forklift driver. We are asking for a signature bond and for no further violent contact. I would ask that in lieu of any anger awareness courses that the court just order that they continue counseling as they have already been doing. That's all. Thank you.
And given their history and the fact that the victim did just say that they had a family violence incident in 2013, and he does have a 2021 arrest for aggravated assault and cruelty to children, and actually that's 2 aggravated assault charges, the state's recommendation is the surety bonds that we recommended and no further contact and a stay away.
All right, I'm going to give a signature bond through the jail. It's been since last year. So it'll be a $6,000 signature bond, which is $2,500 on each of the batteries and $500 on the criminal trespass and the theft by taking. Total of $6,000 signature bond through the jail. And no further violent contact with the victims. I'm sorry?
I want to know if I can speak.
No, I'm giving my ruling. Can't interrupt.
Okay, I'm sorry.
So he has a signature bond through the jail. No further violent contact with Miss Winfrey or Miss Butler. No drugs, alcohol, weapons, or guns while on bond. And since they're receiving counseling and things of that nature, I'll just let them continue with that. And that'll be it. Which position?
This is gonna be Joshua Carter, y'all. Number 6, position number 6.
All right. This is 24 CR 003270A, abandonment of a dependent child support case with a purge.
Yes, state should know it. I think it's
Yeah, what's
660
his
or
purge?
something.
Yeah, what's his purge amount?
That is correct, Your Honor. I do believe that it is 660. Let me double check my records just to perfect the record.
Okay.
Let's see.
600.
You got it.
Yeah, 600 on the booking.
600.
I thought
Yes.
it was 660, but it's 600.
Yeah, it's 600. I thought it was 662. I don't know where I got that from.
Oh yeah, I have 600. Yeah, currently on 600 bond. Yeah, so the state's request is that he pay the purge amount, Your Honor.
Yeah, that's usually what happens. $600 purge. Can't do anything with it.
He has other felony matters to attend
Oh.
to. Okay.
So who's next?
Unfortunately, but unfortunately, Your Honor, I think that time has come where that concludes my business with the court. May I be excused?
Make him
No.
stay. Make him
Right,
stay.
no. Or better yet, bring us some food back or something.
Okay. Happy holidays.
Yeah, same to you. Have a good one. All right. Who do we have next? Who's this?
Position number 30, tab, Mr. Eugene Tab.
Okay. Let's see, 30. All right, this is 24 CR 003277G. Looks like Santa Bias, Eugene Tab. Charge of 1 count of battery family violence. Pretrial.
First, jail was a recommendation.
Okay. State.
Yes, Your Honor. Officers arrived to the incident location, which is 4375 Cascade Road, Southwest in South Fulton, in reference to a battery family violence. Upon arrival, the officers spoke with the victim, Ms. Pamela Cheney, who advised that her and her brother, the defendant, were having a verbal dispute when the defendant began to shove her numerous times, to which she eventually fell to the ground. The defendant then stood over her and kicked her head twice with the toe of his boot. The victim got up and proceeded to call 911, and the defendant snatched her phone from her and threw it against a wall. The defendant then fled the residence. The victim's 12-month-old daughter was also present and crying during the incident. The victim was transported to Wellstar Cobb for a concussion evaluation due to being kicked in the head and having a high blood pressure. Due to the circumstances in this case, the signature bond is what the state is recommending, and that will be through pretrial services. No further contact with the victim, Pamela Cheney. Stay away from the incident location, 4375 Cascade Road, Southwest, and 1 day anger awareness. At this time, I will sound for the victim, Ms. Pamela Cheney.
Pamela Cheney. Pamela Cheney. And the state recommended a signature bond through pretrial. And what was the level for contact?
No further contact.
Oh, no further. Okay. All right, PD Holly.
Yes, Your Honor. As the state mentioned, this is my client's first arrest. He's 23 years old. This is an incident that happened between him and his sister. In the police report, the officer actually noted that she was very intoxicated and admitted to having drank 3 50-milliliter bottles of peach vodka, I believe. Yeah, Taka peach vodka. There was a scuffle that was caused by her because she was intoxicated, which would be my client's argument. He denies completely ever kicking her. Obviously, we don't have any problem with the signature bond. We would ask for no further violent contact. They are siblings, and they do still speak. This happened back in January. He's no longer living at the location.
Okay, no longer there. All right, $2,500 signature bond through the jail. This happened back in January?
Yeah, January 27th.
Okay. 2,500 signature bond through the jail. I guess to stay away from that incident location and no further contact with the victim. And that's it.
Next
What do we have next?
Position number 32, Mr. Antonio Winston.
Okay. It's at 32. 24 CR 003283J, Antonio Winston, charge of 1 count of battery family violence, pretrial.
8th arrest on probation for hit and run and serious injury by vehicle. 2018 FTA, 2018 probation, 2017 entering auto conviction, 2017 shoplifting conviction. That's it.
Okay.
Officers were dispatched to the incident location, which is 112 Dogwood Drive Northwest, Atlanta. Upon arrival, officers spoke with the caller, Tayana McDaniel, who stated that she had gotten into a fight with the defendant, and the defendant had tapped her in the face with an open palm. Ms. McDaniel then called upon her father, who was the victim in this case, Mr. Charles McDaniel. The victim stepped in between Ms. McDaniel and the defendant, at which time the defendant grabbed the victim and struck him, which caused swelling to the victim's face. All parties reside in the same residence. The state is recommending a $2,000 surety bond, no further contact with Charles McDaniel, stay away from 112 Dogwood Drive Northwest, Atlanta, and no drugs, weapons, or alcohol while out on bond. At this time, I will sound for the victim, Mr. Charles McDaniel.
Okay, Charles McDaniel or Tayana McDaniel. All right, we'll keep going. PD Holly.
Yes, Your Honor. My client is 27 years old. He does have 2 children and he is working, currently gainfully employed as an installing contractor. There was a disagreement and the father got involved. There was no physical altercation other than my client stepping away from the situation and trying to separate himself from the other 2 parties who were very angry at this time. We would ask for a signature bond. He does have a job, which we believe he'll lose if he cannot get out. And we would just ask that if there is no further contact ordered, that there be an order for exchanging of the children.
And just to clarify, Your Honor, based on the warrant, it does seem like there was an altercation between Miss McDaniel and the defendant, at which point she did call her father to step in and help her, to which he did come to her aid and stepped in between Miss McDaniel and the defendant. And that was when the defendant grabbed the victim, Mr. McDaniel, and then struck him in the face.
Okay. And we've had no contact, or has the state had contact with the victims?
The state has not had contact with the victims,
No.
Your Honor.
All right, I will order a 2,500 signature bond through the jail. Stay away from 112 Dogwood Drive. No further contact with the victims, Tayana McDaniel and Charles McDaniel. No drugs, alcohol, or weapons, guns while on bond. And I guess that'll be it.
Your Honor, would you order some type of provision so that he can see his child?
I don't know. This happened in front of the child.
The warrant, let me double check the warrant so that I do not misspeak.
Okay.
I don't believe so. I don't think there was any allegation that the child was present.
And I don't see an allegation that the child was present. I don't know if the child's been legitimated. I don't know if they have a current custody arrangement in place. We have not had a chance.
I'd rather not do it without hearing or knowing what the situation is from anybody. At this point, I'm going to leave that open because I don't have any facts to help me determine what I need to do. So that'll be at the discretion of the mother.
Okay, I understand. Thank you.
Mm-hmm. Okay, Deputy Norris, what do we have left?
It's Saint Seren, and we are gonna go to the add-on calendar position number 2. Do I have to see up there? Mr. Palafox, Robert.
Okay. 24 CR 003269G, Roberto Palafox, charging one count of criminal trespass.
4 total, 2017 possession of marijuana, 2012 armed robbery. Jail is a recommendation.
Okay.
Your Honor, I have a different history. So it looks like he actually has 6 cycles. 2021 case with our office that's not showing up on IC for some reason. And I'm that he has 5 arrests that he had for misdemeanor marijuana, and then everything else pretrial said was correct. And the case number that we have for the case that's open in our office is 21R0019118G. And in this case, Judge, this incident occurred May 24th, 2024. Officers responded to the Colonial Square Apartments located at 2637 Old Hapeville Road, Southwest in Atlanta, in reference to trespass. Prior to the officer's arrival, dispatch notified him that an individual was on the property that had been given a criminal trespass warning from earlier that day to specific apartment 9E. And upon arrival, officers saw the defendant eating fruit in front of 9E. They made contact with the person who lives in apartment 9E. Her name's Courtney Strozier. Ms. Strozier informed the officers that she had recently broken up with the defendant. The defendant does not live with her, and she had asked him to leave several times. Like I just said, he does have an open criminal trespass and simple assault case. The state is spending a $2,500 surety bond in this case. A no further contact with Courtney Strozier, a stay away from the incident location, no weapons, drugs, or alcohol out on bond. And if we could sound for Miss Courtney Strozier.
Courtney, what was the last name?
Strozier, Strozier.
Okay, Courtney Strozier. Courtney Strozier. All right. PD Atai?
Yes, Your Honor. My client is 26 years old. He has lived in Georgia all his life. He is gainfully employed working at churches. He has been doing that for over 4 years. He also works another job at Checkers. He has graduated high school, and from what I saw in the pretrial report, he doesn't have any adult arrests. He is recommended as pretrial stated for a signature bond through the jail. I did get in touch with the complaining witness, and Ms. Strozier told me that she did not call 911, that he does care for her 4-year-old child and her 16-year-old child, but they don't live together. So we have no objection to the signature to the stay away from that incident location. She stated that he's a good person and has always been a good person. Your Honor, I would just like to state that this is the address on his driver's license. So I think he did live there at some point, but has moved out. So I have no objection to a stay away. I would ask for no violent contact with the complaining witness. She didn't state that it's a criminal trespass charge. So, and she did tell me that he's a good person and has always been a good person and has never done anything wrong to her. So I would like to ask for a signature bond through the jail. And I guess there's no contact issues here, but a stay away from the incident location is fine. Nothing further.
Okay.
And Your Honor, given the nature of this criminal trespass, and typically there's not a no further contact, but in this case, she is his ex-friend, and he was there earlier that day. So this idea that he doesn't live there, I mean, the police were there earlier that day with him and issued him a criminal trespass warning. So they determined at that time that he didn't live there, and he disregarded that and came back a few hours later. So in this, I think a no further contact is warranted. Our office has not been in touch with the complaining witness. So that's the reason for that request at this time.
All right, I'm gonna order a $2,500 signature bond through the jail. Stay away from 2637 Old Hateville Road and no further contact with the victim in this case. No drugs, alcohol, weapons, or guns while on bond.
Your Honor, on his booking sheet, he has 2 criminal trespassing and a simple assault. Were those 2 charges NOD?
I'm sorry, I can. What she said.
She said there was
Yeah,
2
There was
criminal.
2 criminal trespasses and 1 simple assault. Was one of the criminal trespass NOD also with the simple assault?
it's a bench warrant arrest. It'll go on the SAP counter.
Oh, okay.
Yeah, I'm
It's
showing
like
that's a totally
21.
separate case.
Yeah, it's 21 CR.
Okay. We can go to position number 28. Mr. Randy Stephens.
All right, this is 24 CR 003271C. Randy Stevens, 1 count of simple battery, family violence.
It's his 5th
Pre-trial.
arrest. All I saw was a bunch of driving and a 2021 ID theft fraud. This is level 2.
Okay. State.
Yes, Your Honor. Officers responded to the incident location, which is 1827 Honeysuckle Lane Southwest in Atlanta, in response to a fight in progress call. Upon arrival, the officers spoke with Camille Webb, who stated that she had been physically assaulted by the defendant, who is the father of her child. The victim stated that the defendant slapped her in the face and head with his palms and grabbed her by the hair, which pulled out one of her braids. The victim stated that this occurred in the presence of their child. The officer did not see marks, swelling, or missing hair on the victim. Our office has had a chance to speak with the victim, who stated that her and the defendant were together for 6 years. They have a 4-year-old son together, and they do not reside together. The victim stated that they don't have a domestic violence history, and she's not in fear of the defendant. She confirmed the events in the warrant and stated this was a first-time incident and that she would like no further contact, anger awareness, and parental classes. The state is recommending a signature bond through pretrial services, no further violent contact with Camille Webb, no drugs, weapons, or alcohol while out on bond, 1 day anger awareness. And at this time, I would sound for the victim, Camille Webb.
All right, is the victim Camille Webb on the line? Ms. Webb? I don't think there's any outside people left. I don't know. All right, keep going. I see a Mickey and a Neon Sharice. I'm not sure who those people are. Are they employees or outside people? Mickey? Who's Mickey? Mickey. And Neon
Yes,
Sharice.
I'm just an outside person.
What case are you here for?
I can't hear them.
Are you here for a particular case? All right, go ahead, State. Mute yourself. I don't know what case you're here for. I thought she said I'm an outside person. Did she say that?
That's what I heard.
That's what I heard as well.
What case are you here for, Mickey? Go ahead. Huh?
The defendant is gesturing that it's him.
Oh, she's here for this case? Oh, well, is she gonna talk or not? Is she the victim?
The victim is named Camille Webb.
Right, but sometimes people get on with other people's devices and it's a different name. That's why I was asking. All right, well, she's not gonna say much. We'll move on.
Would you like me to go ahead, Your Honor?
Yeah, go ahead, PD Holly.
Okay. My client is 25 years old and he actually was just laid off. He's currently on workers' compensation after he experienced a workplace injury. He's working for Pepsi. My client denies the allegations. He said that they were having an argument. He decided to leave. She started throwing his stuff at him and he left. The officer did make a note that there was no missing hair and no injuries. She specifically said he pulled out a braid, but there was no missing hair. We would just ask for a signature bond and for no further violent contact as suggested.
All right, $2,500 signature bond through the jail. No further. Well, who spoke to Ms. Webb?
The state said they did.
Our office did, Your Honor.
Oh, and she requested no further violent contact?
Yes.
Okay, no further violent contact with the victim. And was there a stay away or not?
No, we did not have a stay away as she requested just no further violent contact.
Okay, and just no
Well, does the
further
defendant? No, they don't reside together. Never mind.
Okay. All right, so $2,500 SOB jail, no further violent contact with the victim. No drugs, alcohol, weapons, or guns while on bond. That'll be it.
Hey! Let me up, man.
We can, Your Honor, we can go to position number 20.
Number 20.
What's up with Craig Washington?
The waiver.
He's a waiver.
Waiver.
Which one?
31.
31's a waiver. And we're on 21.
Yes.
Deontay Mitchell.
Yes, ma'am.
Okay.
Yes, Judge.
24 CR 003260G.
Yes, and Your Honor, can we